My please, Your Lordship, that one IA may not in criminal appeal may be listed for order, my lord, is on first August, my lord. Okay. May I take your lord? Prayer for listing of one IA. Prayer for what? IA for suspension of sentence and procedural. When? Next week, any date, Lord. May I take your lordship? Lordship, I'd like to mention for listing of an IA or suspension of sentence. When? Okay, by Friday, if possible, Lordship. Oblige, Lordship. May please, Your Lordship, with regard to item number 3, my lord, I take it 3, I take it consent of the respondent. And their tag matters of 2 and 4, my lord, I have taken consent of the applicant also. It may come up 2 weeks, my lord.
On the prayer for adjournment made by Mr.
V.K. Barua, my lord.
V.K. Barwala, counsel for the appellant in the criminal appeal 74 of 2021, which is not objected by the other counsel. This is the matter.
After 2 weeks,
After 2 weeks.
have your bit.
2, 3.
Next, please, Lordship. I take to mention item number 8 of today's list, my lord.
8, yes.
In this case, my senior is Endega, who is amicus curiae, my lord. He is suffering from severe back pain and vertigo, my lord. So he is unable to present before the court today, my lord. And doctor also advised him to take a bed rest, my lord. So I'm saying this matter will fix the matter again.
Okay, right. On the request for adjournment made on behalf of Mr. N. Deha, Canada, who is said to be suffering from back pain.
Back pain and 6
vertigo.
vertigo.
Leave the matter after
Any day in the next, after 10 days, my lord.
after 10. Maybe no, okay, after 10. With back pain, if it really back pain, that is not terrible. I was in Delhi for 3 weeks.
Lord Chef.
Undergoing physiotherapy.
Please, Lordship. Appeal against conviction, Lordship. Conviction is under
Mr.
and Hassan, Lordship.
And has not learned counsel for the
6 of Poxo Act.
who submit that the appellant has been convicted under section 6 of the POCSO Act by the special Dutch POCSO in POCSO case number 149 of 2024, arising out of Lekha Pani PS case number 65 of 2024. With the appeal call for the trial court record. If you notice that Mr. Bunde had a returnable in 4 weeks, Miss
SH for a doctor.
ST
SH for.
SH Bora.
Yes.
SH Bora. Dana Rabitin CP extra notice on behalf of the state.
Okay.
Notice we serve the respondent number 2,
The number 2 is the mother of the victim.
who is the mother of the victim, through the OC of the Ekapani PS. This is the matter of the point.
Lordship.
Public.
May it please your lordship. Well, initially we filed a criminal appeal for 4 accused appellant, and 2 were convicted for life for the offence under section 302, and the other 2 were sentenced to 8 years imprisonment. Then in
2 302
2
and for 2
for 2 they were convicted for 8 years for offence under 307 and 326. That your lordship will find the observation in the criminal appeal number 434 of 2024. Page, my lord, 168. Paragraph number 63.
Yeah.
Accordingly, accused named Kalam Sheikh, my lord, who is before your lordship now, accused of and Sobur Ali are sentenced to undergo RI for life for committing the offence punishable under section 302 of IPC, and also to pay a fine of rupees 5,000. Only in its default, further RI of 6 months. Further, accused number 5, Sobur Ali, and as well as accused number Anwar Hussain are sentenced to undergo imprisonment for 2 years for committing the offence punishable under section 324 of the Penal Code, and also to pay a fine of rupees 1,000 only in each in default, further RI of 1 month. A5 and A6 are also sentenced to undergo imprisonment for 8 years for committing the offence punishable under section 307 of the IPC and also to pay a fine of rupees 2,000 only in its default. Further RI of
So
two,
Sobur Ali is also punished under 307 also.
yes, madam. And also to pay a fine of rupees 2,000 only in its default. Further RI for 2 years. Accused number 3, Saurabh Ali, sentenced to undergo rigorous imprisonment for 5 years for committing the offence punishable under 326 of the IPC and also to pay a fine of rupees 3,000 only in default. Further RI for 3 months. Further accused number 3 also sentenced to undergo.
The others were not interested.
Yes, but 4 are there.
Four and
Four persons were there. 2, my lord, we got it segregated from this appeal, and now those for the 2, the separate appeal is pending before the learned single judge because since it is only 8 years conviction. Since these 2 are for life, that's why these 2 are before your lordship. So we have filed a separate appeal. Now that will be hard because the division bench at that particular point of opine that since it is 8 years, so but it
then
could
the evidence is the same.
yes, it could have been hard, but when the court makes
There's a likelihood of different findings being made now. Supposing we interpret or we find on the basis of evidence that it goes this way and the single judge goes this way in the same evidence, then what is going to happen?
well, it was for that reason only I filed a composite appeal for all the 4 persons, but the honorable division bench directed me to file a separate
Which
appeal.
order? Which order?
1912-2024. Or your lordship can now ask the registry to take those 2 also. I don't have, I can argue before the single bench, division bench.
Yes, madam, what do you say?
Lordship, actually, division bench can take up the matter where his conviction sentence beyond 10 years,
No, what he say
my lord.
is that everything has occurred out of the same event.
True.
Okay. Now, 2 of them had been convicted under 302,
Yes.
307, one of them. And then the other 2 have been convicted for a period of less than 10 years,
10 years.
but on the same set of facts.
Yes.
Same evidence.
So now, on the same evidence.
Right.
Now, those persons who have been sentenced to period below 10 years, they are being heard by a single bench, and we are hearing. The division bench is hearing the other 2. All of them arise from the same
Same
set of evidence,
Same, that's,
same evidence.
yes.
Now, there could be a different finding by the single bench on the evidence. that is-
Appreciation of the evidence.
And we also could have a different finding from the single bench.
No, your lordship will be subject to correction, be concerned with the appellant who are before this bench,
Correct.
where,
Correct.
wherein sentence is given more than or life or they
No, no,
forget.
correct,
Well,
correct.
How the accused appellant will be prejudiced because this is a division bench. Any observation made by this division bench will be binding before the single judge.
Correct.
They will show it as a precedent if it goes against me. If it is in my favor, I will show it that the honorable division bench has already observed that.
No, where lordship, learned trial just must have appreciated the evidence and for that reason, less than 10 years were given to them.
No, but then you see, supposing, according to the evidence, say, the trial judge has taken the evidence to prove a certain thing. And we agree with it. Supposing we agree with it. We agree with the trial. But on the same set of evidence, with regard to 2 other persons, the single judge comes to a different finding. Then what happens?
Maybe.
Can-
There is a judicial order, my lord, to like segregate the thing and
And-
place it before the
No,
single bench as my
That,
learned friend is
that's what we
submitting.
can always modify again. We can always put it
Leave
together.
it to a lordship,
And we're just thinking aloud
my lord.
as to whether there can be, whether this can cause problem. There's a chance.
It will be prejudicing the accused because any observation made say.
No. Leaving that aside,
Yes, sir.
supposing the single judge has taken a decision and given a finding on the evidence that you,
I appreciate.
can we as a division bench now come to a different finding? Because this is not going to be an appeal against the decision of the single judge.
So far that judgment will concern, it will be functions official. So far that learned single judge is concerned, we
Or
have to
the
go.
same set of evidence.
We'll go, we have
Two
to go.
different interpretations. Or
It-
two different findings.
My lord, it was under that logic only I had filed it initially for all the 4 appellates. Because nowadays we find,
Anyway, this case, is there any eyewitness?
yes, ma'am.
There is.
Let me place the facts. My lord, first, when we came before this honorable court, my lord, in case of one of the,
Yes, sir, very good.
yes, ma'am. What do you have to, I will support with that. Eight, the criminal appeal number 434 of 25. I had to, put one appeal to refer for it. Yes, yes. I had to number say, 1263 of 2020.
Yes, there are.
Yes, ma'am. My lord, your
It
loss,
can be disposed of.
the IAS can be disposed of.
She used to file one compilation,
Yes, yes.
raised it on the last occasion, raised to a director to verify the document submitted by my learned friend in the memo of appeal, whether it was like in a proper form or not.
My lord, we have
Lord,
annexed.
Can you have a look at the
Hello.
earlier order, last order? Main-
No, is there a paper book has been made or not?
But we have given the compilation of all the deposition of the witnesses and including postmortem report.
Okay.
Today is consideration of the bill and for
There is consideration of the bill.
for the bail of the 2 of the appellants. Plus, in case of one, there was an order from the Honorable Division Bench because we have taken a plea of juvenility. And then the court, so let me place it, if your lordship, I'll place it in a sequence. So, but only in the case of the juvenile, my lord, we had filed a
Juvenile with regard to whom?
Bodiat Jaman Sheikh alias Kalam Sheikh.
If there is a plea of juvenility, then that 2015 Act. Section
No, this will
90
be under the old act because this is an offense of 2013. But if that section, perimeter section is the same. Earlier it was under the rule, but now they have compiled it into section 47 of,
Rule 12
yes, yes. 7 and 12 of the old act. Now,
of the rule,
yes, madam. Wait, sir.
2007.
Yes, madam. Madam, 2007, Rule 12(3)(b) and Section 94(2) of the 2015 Act. It's the same.
2015 Act will hold the fee, right?
No, madam, the offenses of 2000.
Maybe, but this is only with regard to the to find out.
Yes, madam, it's same. It's the
Yes.
same. It's the same. Both the sections are same.
How does it prejudice you if
No,
2015 Act?
no, I'm not prejudiced. I'm not prejudiced.
No one is prejudiced.
No, nobody is prejudiced. Your lordship will kindly see the order dated 19, oh, 8/1/2000 in High Court order. High Court order of 19/12/2024 in regard to the direction
With
given.
the appeal.
Yeah, yes, ma'am. IA number 1263 of 2024.
19/12/24 order.
Yes, ma'am. Of in the IA number 1263 of 2024.
19/12/24. Okay.
Yes, ma'am. Or in the IA 1264 of 2024. Your lordship will kindly see. You can show the petition.
So has the report been made?
Yes.
Yes, it was against him because according to the learned trial judge.
My lord,
the
will not
documents
jump
were-
into conclusion whether it is against me or fake.
No,
Let me
no,
place
because
it.
it was a learned
Does the-
trial court came to a finding, the document submitted by his client is a forced one. So on the last occasion, he prayed for ossification test. On the last occasion, when it came, your lordship, it was also directed to file a compilation, whatever is submitted in the memo of appeal.
So let the authentication test be done. What is it?
Yes, ma'am. By the medical board, my lord, that's the next option. And your lordship will see the
Is
report.
there any bar? Supposing his document is false,
My lord.
that means it cannot be proved. That say if it was a genuine
My
document
lord.
and the document said that he was of age or he was not of age, that document could have been taken into consideration by the court to come to a finding
My
with
lord.
regard to whether he's a juvenile or not.
But-
But if the document cannot be relied upon by the court, then the next thing to do is the authentication.
Lordship, may
That
I
is
have
by
a-
medical board. 94 to the- My lord, my lord, with utmost respect, when the report, what does it say? It says that I have brought one register to the court where this date of birth is not there. He during cross and all, he admits that there may be other registers also, other than this register, which I have brought into the court. Then he looks into the birth certificate and at the bottom he finds the 2015 or 15-16. Then he wants to say that this birth certificate is printed on 2015 or 16. But he doesn't say that suppose a person is born prior to the date in the register, then the certificate can be issued subsequently also. So, but that's why he draws up a presumption that since it is not registered, since it is the certificate of 2015-16 prior to the means after the incident, that's why he draws a presumption that it is fake and bogus.
Anyway-
So the next course that has to be adopted under the juvenile justice care, there are steps given. So we are praying that there, as your lordship has said, that there is no bar to do a ossification case because which the learned session judge ought to have been done in terms of the order dated 1912 is the next step is the ossification test by medical board and to submit the report. And if the ossification report comes, it is +-2. That is so far the juvenile accused is concerned. So far the other accused is concerned, I will place it on merit why the bail has to be may be considered by this honorable court. That's one. And so far the paper book and all what my learned friend has said, that is it. When the matter will be finally heard, then whether the paper book will be necessary or not, because we have given all the documents which are there in the like the deposition of the witnesses.
No,
and
you
the
see, whether paper book is necessary or not,
Ah.
will have to be decided prior to the hearing, not after the
Oh,
hearing.
yes, prior to the hearing of the criminal appeal. Today we are on the interlocutory applications for consideration of the bail. And we have given the documents to show.
But without the document,
No, we have the documents. We have given, that's why this criminal appeal is so thick. Otherwise, it would have been a simple memo of appeal. We have taken the general grounds because we in a criminal appeal, we can rely on all.
anyway, the thing is that
Your lordship will see the last order dated
if
20
documents are not there, if the documents are not there, all the documents are not there.
It is there. Your lordship will see the office note. Your lordship will kindly see the office note.
Look,
Because the
please-
last,
Please come to the order dated 23/7/25.
yes, Malak, your lordship will see the bottom. Office is directed to verify the said records along with the enclosures made in the memo appeal, in which case the requirement for preparing the paper book may not be there, as paid list on 29/7/2020.
So-
After this, Malak, there is an office note. The cause list says that there is an office note. Yes, okay.
Are found to be compatible for preparation of paper.
Yes. And that's why I have given the evidence, my lord. I will not mislead this honorable court, my lord. Because this is my appeal, I have to rely on it. I have to see that it is.
But then the other thing is that if you
Yes, my lord.
supposing we do not find your submission to be enough
Yes,
to give grant of bail,
yes, my lord.
to grant bail. Then the next issue will be again with regard to your juvenile. So let that be there also.
No, my lord. So far this accused is concerned, my lord, I am ready to argue on merit. If your lordship finds that I don't have merit, your lordship will reject my bail application. That's as simple as that, man.
Because he's pressing for juvenility.
That's for the other accused, not for this accused. This accused, I will argue on merit.
For which accused?
This is for the accused, Sabur Sheikh, Abdul Sabur Sheikh.
And what about, no, we'll decide both in that case.
No,
Because you see, one.
no, my lord, juvenile, if
See,
the.
juvenile is this.
Yeah.
Once the person has been found to be juvenile. The trial that has been concluded against that person,
Yes,
that remains.
yes.
The only thing is that you.
I'll argue for
make
both
beyond
on merit.
guilt, that's all.
Yes, ma'am. I'll argue for both on merit. I'll argue for both on merit. Because if the next ossification repeats comes that I am a juvenile and plus minus I will fall in the juvenile, then I can always file an application.
Yeah, you have been in custody for how long?
Well, from the date of the judgment,
27/9/24.
Approximately 300 days today, he is in custody for 9 months and 26 days. 10 months almost.
And prior to the decision of the trial court,
They were arrested and those period will also count.
actually, so
Yes,
that
right.
period how much?
That your lordship will find from the, they have given me the forwarding report. I'll just
As
calculate
a
it.
UTP, how long was he?
UTP will be as a, no, prior to filing of the charge sheet, he was there in jail.
So long as he's an under trial prisoner,
Yes.
as long as the judgment conviction is not there,
Yes.
that period is.
Yes.
UTP anyway.
So your lordship will, 10 months plus 3 months, that will be around, 11, 12, 13 months.
Okay, so he was released due to 167.
Yes.
He
3
called-
months, 3 months during investigation, then from the date of the impugned judgment, which will be almost 10 months.
302.
302. Even then, I say, I'll argue on the merit. So far, I'll not say for the juvenile, but for the other accused, but I'll.
Look, if you're going to argue on every.
No. I will be very specific.
How
So
much?
far,
We'll give you 10 minutes.
your lordship, your lordship will not have.
10 minutes.
Yes,
How long are
yes,
you? How long do you want?
yes, my lord.
No, you
We'll
tell me
take
how
it.
long do you
We'll
want?
take the challenge, my lord. We'll do it 10 minutes.
No, you tell me how long. I'm going to mark it. How long do you want?
My lord, I'll finish it by 11:50.
11,
15.
15.
Yes, I'll take the challenge, ma'am.
Okay.
Your lordship will kindly see page 41, the FIR. No, ये दिखेगा कभी। FIR is dated 11/12/2013. I am the accused number 1 is Kalam, the juvenile.
11, 12, 2000.
13 Kalam. Accused number,
This is in the criminal appeal.
yes, madam. Criminal appeal number 434 of 2024. Accused number 1 is Kalam, who is the juvenile in conflict with law. Accused number 2 is Sabu. And the date of occurrence, your lordship will find from the paragraph, bottom 3 lines, 10/12/2013 at around 8 p.m., which is in the evening. Then they were all waiting.
Where is this Bodiot?
My lord?
This Kalam, okay, Kalam is Bodiot.
Yes, sir. Now, so far the FIR is concerned, my lord, Sarvesh Ali, he died before the trial. So this FIR could not be exhibited. But the genesis of the offense is that it occurred on 10/12/2013 at around 8 p.m. Then your lordship will find at page 42 the name of Bakkar Ali, who is an injured and eyewitness who is PW8. This is the solitary eyewitness, Bakkar Ali, alias Bakkar Ali, who is PW8, who is also the injured or the stamp witness and is also an eyewitness to the occurrence, who actually was accompanying the deceased. Then your lordship will go.
So Bakar Ali is
PW8.
PW8.
So I'll take your lordship directly to the evidence of PW8. 2 lines only, madam.
Page?
Page 94. One, two, three, fourth line, your lordship will see at page 94
Yes.
in the deposition. The accused Kalam, this is the juvenile in conflict with law, suddenly came there and inflicted a blow with the dagger in the abdomen of Said Ali. So, abdomen, Said Ali, Kalam. This is in respect of juvenile. The next your lordship will find is the second appellant. Accused Sabur Ali inflicted a blow with knife on the backside of head of Said Ali and he sustained injury. This is in respect of the two. Now I will take your lordship to the postmortem report to show the injury on the deceased, because I have to show that this ocular evidence matches with the medical evidence. Now your lordship will see.
I suppose that it doesn't mean that has to be exact somewhere there.
Yes, but
It depends upon the angle.
no, from the post,
Yes, that-
no, from the postmortem report, your lordship will see.
Wait.
Yes, madam. 58. Page 59 are the injuries, madam. ये खाली नोट पर का तो वो नोट पर एक एप्रिल नसल ना नहीं ये मेरे नोट के था ना पोस्टमार्टम रिपोर्ट में वो कहाँ से मैंने मुआवजे का नोट कुछ ना लिखी सी अरे मैं लिखा था वो कहाँ पे वो एक और ये तो ना हमारे का फॉरवर्ड कर दो your lordship will kindly see page 59 external wounds. Injury number 1, incise wound of size 7 centimeter into 4 centimeter scalp dip. Scalp dip means mother, it is only superficial injuries, not deep enough to touch the skull. The skull is intact and there is no injury on the.
Thank God,
Yes.
but it didn't occur by itself.
No, you will not ridicule me and laugh while I'm making a submission. I don't expect
No,
this.
no,
Let me.
She's not laughing at you, she's laughing at my explanation.
Yes, well, I'll give it. Well, your lordship will kindly have bear with me. Incise wound of size 7 centimeter into 4 centimeter into scalp dip, present over left parietal scap
What do
located
you
at
mean
two.
parietal? Parietal means?
Parietal means this area. It will the left parietal will be this here. And your lordship will see the evidence it was on the back side. And your lordship will see parietal scap located 2 centimeter left to midline and 30 centimeter above the superciliary ridge. Superciliary ridge is this above the eye. So it will be here somewhere in the crown, not on the occipital or the back side of the head. Because the witness has said that this accused Sabur had hit on the back side.
Okay.
I'll not say with mathematical, but it appears that this wound is superficial because it is only a simple contusion. I will show it from the postmortem report. Your lordship will find at the bottom cranium and spinal canal, scalp. Contusion of size 9 centimeter into 4 centimeter present over left parietal scalp, located 1 centimeter left to midline and 8 centimeter above superciliary ridge, which is blue in color. Blue in color means it is fresh. Then your lordship will find skull healthy. So there is no fracture or any injury on the skull. It is all superficial. Now your lordship will see
Where have you written? Where have you read? Skull, healthy?
cranium and spinal canal, page 59 bottom, scalp, skull, vertebra, scalp, contusion of size. Contusion is not grievous, madam. Contusion of size 9 centimeter and 4 centimeter present over left parietal scalp, located 1 centimeter left to midline and 8 centimeter above superciliary ridge, which is blue in color. Blue in color means it was just fresh because after 8 to 9 hours, sometimes the injury for accumulation of that. Then your lordship will note that the skull is healthy. Then your lordship will look the opinion. This is very general opinion, not directing against that. This is the particular specific injury which has resulted in the death. I will show from which it has resulted in death. Death was due to hemorrhage and shock as a result of injuries sustained over the body as described. All the injuries were antemortem caused by moderately heavy, double-edged, pointed tip, sharp cutting weapon and homicide in nature. Approximate time since death 2 to 8 hours. Now your lordship will see, so far this skull injury is concerned, the doctor who first examined, he says it is simple. It does not doctor. Doctor today. Yeah, the next question, doctor. Huh? PW. Your lordship will kindly look at PW 9. Just a minute. PW 9. Page 104.
Yes.
Page 106 is the relevant.
Yeah.
The scalp was intact. There was no injury in the scalp. The presence of surgical stitches means that the disease was earlier treated by some surgeons. Its contusion means it is a superficial layer, my lord. Now your lordship will see PW1 at page 83. Just one page in the position.
Page?
Page 83. Your lordship got it?
Yes.
When I heard hue and cry, I came and saw that Bakar Ali pressing Sahid Ali with hand on his abdomen. I saw the injury of Sahid Ali and blood was oozing out from his abdomen. The injured was taken to the hospital. So he established the presence of Bakar Ali at the place of, Bakar Ali at the place of occurrence, and he saw that there was only injury on the abdomen and which can be attributed to the juvenile in conflict with law. Now your lordship will see the next page at page 84. I went out and saw that the abdomen of Sahid Ali came out and saw Bakar was pressing the injury of Sahid Ali. I do not know who assaulted Sahid Ali. The PW1 also did not see who assaulted Sahid Ali. That is there. PW3 is a hearsay witness. Your lordship will see. I heard from the people of the locality. PW3 at page 85. Similarly, my lord, PW4 is also I heard from the people of the locality. PW3 and 4 are hearsay witness, my lord.
No, basically, PW8 is the most important.
Important. But before that, your lordship will look at the PW5, the injury, the doctor who first examined them. Only in case of one, there is a grievous injury. So your lordship will see Manikula Sikdar at page 87.
PW5.
PW5, the first doctor who examined. 3 injuries are given for Manikula Sikdar. Your lordship will see the next page, page 88.
Dr. Rabin Sharma, PW5 is the first doctor.
Yes,
Is the first doctor who examined
the injured,
the disease.
not the disease, injured.
They're into your diabetes.
Or then
Yes.
injured, I will.
Now your lordship will see.
That's it.
Now your lordship will see.
Who is the injured eyewitness?
Your lordship will see Manikula Sikdar. First, your lordship will see. Manikula
PW.
PW7. Now your lordship will see the interesting part here. Manikula Sikdar, your lordship will find the doctor has said fracture on the ulna left. Ulna is this foreign part. And your lordship will see first 2 simple, third is grievous. Now your lordship will kindly see from here the deposition of PW7.
Which page are you reading?
I'm reading it from page 87 and 88. Fracture of the ulna is the grievous part.
That is doctor.
Manikula Sikdar, cut injury in the left elbow, abrasion in the chest, and fracture of the ulna left. Ulna is the foreign part, madam. So age of injury phase, simple, grievous. Heart is grievous. Now your lordship will see the deposition of PW7.
No, what are you trying to show by this?
My lord, the doctor in his report has said that this particular PW7 has grievous injury. But if your lordship looks into the deposition of PW7 and 91, he doesn't say that he has sustained any injury.
No, but how is this relevant? Who had died? The person who died
Shahid Ali.
was Shahid Ali.
Yes. Now, in case of Shahid Ali, your lordship will see your lordship will see page
Shahid
88.
Ali had died.
Shahid Ali. The eyewitness is Bakar Ali.
Now PWA
Yes.
had seen the 2 applicants here.
Yes.
And the person who had inflicted the injury on Shahid Ali.
Yes, ma'am. Now your lordship will see to test the veracity of his statement, page 88, the injury sustained by Bakar Ali.
Yes.
Page 8, Bakar Ali. Fresh, simple, caused by server object. Now your lordship will see The evidence of PW8 at page 94 again. Your lordship will see, accused Sobur Ali inflicted a blow with the knife on the backside of Sobur Ali and he sustained injury. This is not in tally with the medical report and the postmortem report. It is only a simple injury and not grievous, simple contusion. I will show it, my lord. This one. Your lordship will see, accused Sobur Ali inflicted a blow with the knife on the backside of Saeed Ali and he sustained injury. Then your lordship will see, then all other person attacked Saeed Ali with sharp pointed weapon influencing on the back of Saeed Ali. When I tried to rescue Saeed Ali, accused Sabur inflicted a blow on the with a knife on my hand, and I suffered injury on my left hand. This is an exaggeration, my lord. He is trying to exaggerate for the first time in the court what has not occurred, my lord. Because this does not support by his own medical report. This when I
But then you see Dr. Ali 88, it cut in the left forearm.
your lordship will see.
Dr. Ali did the cut.
When I tried Saeed Ali accused, your lordship will see Bakar Ali cut in the left forearm.
So then now they
And you see cut injury in the left skull. And what is the observation? Simple, caused by sharp object. Simple. It's not grievous. So we are not doubting the presence of Bakar Ali at the place of occurrence, because it is my duty as an officer of the court to show that Bakar Ali was present at the place of occurrence. Now Bakar Ali tries to implicate Shobur by saying that I have given a knife injury in the back. That again, your lordship will look at page 59, the postmortem report. আৰু এটা কৈছে কোনোবা এটা এভিডেন্সত চাচোন বাকাৰ সেই ইঞ্জুৰি আছিল বাকৰটো এইটোক এক্সামিন কৰিছিলে আৰু কি কৈছে যে এইটো simple. Now your lordship will see external wounds, incise wound. This is the first injury attributed to Shobu.
You've got another 3 minutes left.
Yes, I'll finish it. Shobu,
Left
page 59.
59.
Yes.
Yes.
You will also see incise wound. This is the injury opined to
Number
Shobu.
5, with number 5.
Page 59, number 1.
For inside wound, yes.
Yeah, this is the injury attributed to Shobu. Now, second is surgical wound. Third is surgical wound.
Attributed to, no, this is the rule. This is with regard to the examination of the deceased.
Yes.
Correct.
Because none of the witnesses have said that except the backside of the head except PW8. PW8 says that it is by dagger, whereas your lordship will see from this injury that this injury is a simple injury. It is simple contusion. It is not grievous. And the opinion of the doctor is that it is a death due to hemorrhage, but the death has occurred. And your lordship will see injury number 3, surgical wound. Injury number 2, surgical wound. Then injury number 4 is scale wound. Scale wound means it is not fresh. It may be for any other reason. Then your lordship will see the incised wound over left plum. This is a defensive injury. So he must have died, my lord, because your lordship will find that page 60, the peritoneum, the injury in the abdomen. Disease का भी एग्जामिन किया था एक डॉक्टर देखो to sum up, my lord, so far the injury on the head is concerned, and your lordship will find, if your lordship looks at page 59, the person has died due to the injury in the abdomen because there was 2 liters of blood inside the peritoneum, because the covering of the stomach and the injury attributed was that he died due to the injury caused by Kalam on the peritoneum. This is not a case of 149 because there is the learned judge, trial judge has observed that there is no ingredients of section 149. So we have to decide each of the injuries which is caused by a particular accused. We have to look into that. So PW8, the injured witness, is the solitary injured or the eyewitness to the occurrence. He says that so far Kalam is concerned, your lordship has said, Kalam I cannot praise because of the specific allegation at this moment. Kalam can be only saved on the plea of juvenility, number one. So far accused Sabur is concerned, your lordship will say the injury attributed to Sabur is on the backside of the head of the knife. The medical or the postmortem report clearly, it is clear from it that it is only a contusion. There is no fracture of the far head, and it may be caused by any blunt object, even by falling on the ground. But your lordship will see from the doctor's evidence that the opinion of the doctor is on a general omnibus statement. He has not said particularly that due to the injury in the abdomen or the head, he has said simply hemorrhage. But if your lordship looks into the postmortem report, your lordship will find that it is, if your lordship looks into the peritoneum, it will find that it is filled with 2 kg, 2 liters of blood. Probably because the liver was injured. So the liver is a vital organ in the human body. In the abdomen, he must have pushed the knife inside, and that's why the accused has died. That's why I respectfully submit that so far Sabur is concerned, looking into the evidence at this stage, my lord, your lordship may kindly consider the bail of Sabur Ali. The final hearing on the appeal, your lordship will decide whether his conviction can be upheld or set aside.
We are deciding on both. Bodyod and
Bodyod, your lordship will, I cannot, your lordship will not record it. Now it's very difficult to make it online submission, or I can concede. Because Kalam, I can say that your lordship, that Kalam has caused the fatal injury by stabbing in the stomach.
You see, we are deciding on both. With regard to the juvenility, the report can be made. Depending upon the report,
Kalam's bail can be also
can be
decided.
decided separately.
Yes, ma'am.
At the main appeal.
Yes, ma'am.
So that is a different issue. Let us see.
But so far Sabur is concerned, my lord, I'll show there.
No more showing. Enough time now. Yes.
And if I have, because due to the paucity of time, I could not read the entire evidence of PW8. PW8 is an interested witness because there was a life insurance policy of the deceased, and after his death, he got the money in his account, and he married the wife of the deceased. And if your lordship reads carefully in between the lines of the evidence, your lordship will find that the injury which says is in the abdomen, the injury was caused from the front, in the statement of the witnesses. But in the medical evidence, if your lordship reads it carefully, if your lordship sees the injury, it is caused from behind. Because as a defense counsel,
The council enough.
well, I leave it, my lord. If your lordship,
Someone else.
Lordship,
Only a 4:30 p.m.
I am not sure whether my learned friend is arguing on merit of the case or he is pressing on the interlocutory application. Lordship, because in order to ascertain that he has got a prima facie case, your lordship, for granting suspension of sentence, one should have a prima facie case on merit, my lord. But he is going into the every evidence evaluation. Lordship, I will be relying on the evidence of PW7 and 8, your lordship. PW8 is eyewitness to the occurrence. And he, lordship, from his deposition, my lord, he says that he witnessed this accused person, lordship, inflicting dagger blow on the abdomen of the deceased. And the present applicant dealt a knife blow on the head of the deceased. Present applicant means, your lordship, Sabur Ali. And your lordship, and other accused person also attacked deceased with sharp weapon. And I'll be relying on the postmortem report, lordship, because the opinion of the doctor is only suggestive, your lordship. Because lordship, whenever takes up the criminal appeal, always go to the contents of the postmortem report, my lord. So postmortem report is very much clear, my lord. Condition at page 58, my lord.
Yes.
Condition of subject stout, emancipated, decomposed. A male dead body of average build, so complexion, dirty complexion, dressed with black colored printed shirt, brown colored worn t-shirt. Surgical bandage present overhead and abdomen. Eyes closed, mouth partly open, body is warm so. Rigor mortis is present, fully developed. Lordship, then position of wound's position, incised wound of size 7 cm to 4 cm and scalp deep, present over left, right and scalp located 2 cm left to midline. So there are wounds on the vital part of the body. as a result of which the person died. And your lordship, the injured eyewitness account, your lordship, he stands the better footing than the eyewitness, your lordship is aware of. He also received injury, my lord. So how can my learned friend say that this accused persons are not involved with the crime? They were very much present there. And the witnesses have uttered their word, more particularly witness number 8 and 7. So in the event of the matter, your lordship may not grant suspension of sentence.
What about that juvenility of
Penalty point, I have got a point to argue, your lordship. I'll be relying on section 94. When the ossification case could be ordered, my lord. Section 94, 2, 3. Lordship, it says, my lord, first is the date of birth certificate from the school or the matriculation or equivalent certificate. And second is the birth certificate given by a corporation or municipal authority. And only in the absence of 1 and 2 above, age shall be determined by ossification test. In an instant case, it is not a case that they did not have any document, birth certificate, but they had the document which is the first one. But your lordship may not hold that they did not have the document. They had one. So in the event of the matter, whether directing ossification test will be the right approach. My response is sufficient. Leave it to your lordship.
so according to the appellant, the applicant, he studied till which class?
And
He is a illiterate.
Illiterate. Then what document do you have?
The birth certificate I gave, the birth certificate, the doctor who came as CW1 submitted before the court that he has brought the register which does not have the, your lordship can see the evidence of CW1 and the
See?
cross. Well, this was, it is in the LCR because it was, we could only read it. We were not furnished with the copy. It is there in the LCR. I will take it out for your lord. We'll just take it out. It is in the IA, your lordship. It's not there. It's in the IA. So. Somewhat we fingerprint it also. Well, sometimes in we should not miss well, with utmost respect. They said that sometimes justice in haste may be sustained and denied. Well, why we took the plea of juvenility, your lordship will see the 313
Did
statement.
you take it during the trial?
No, juvenility plea, we did not take it during the trial, but the Honorable Supreme Court in a number of judgment has said that the plea of juvenile can be taken at any stage, even after the pronouncement of the judgment. And when I took it, yes, your lordship will see my 313 statement. When I 313 statement, when the juvenile, well, your lordship will kindly bear with one.
This is not an appeal. You want only the first appeal.
No, and prima facie, my lord, I was only trying to show that the statement which was given by the PW8, it doesn't correlate with the medical evidence because the medical evidence, it is only a simple contusion or a simple injury, skull is intact. That is the only point, my lord. And why we took the plea of juvenility, because when we were examining 313, we said that the age was 26 years. If you do it backwards, then it will be on the day of the occurrence, I'll be around.
According to you, the doctor's evidence
Yes.
is basically to the fact that it was a simple injury.
Yes. And the other injuries are all surgical injuries and some injuries are stale. A person who has done with the postmortem report has been done on the next day. The injury can't be stale because these are all maybe old injuries, man.
And for that, they are relying upon the
Injury number 1,
CW5.
yes,
CW5.
yes. Both his deposition as well as his postmortem report. PW9, not 5. PW9. Doctor who conducted the postmortem is PW9. that your lordship will find at page 104, where he says that the scalp was intact, there was no injury in the scalp. Because the scalp starts, it's only the shoot. Page 104 is the PW9 and page 106 is the cross. The scalp was intact. There was no injury in the scalp.
You have not read PW9 at all.
No, I have read, my lord, the cross I have read that the scalp was intact. PW9, the doctor, 104.
He's the professor, Department of.
Yes.
Physics.
He is the person who did the postmortem of the disease.
Wait.
Then your lordship will see his cross at 106.
One to see a predictor. And one to the doctor. Where are the patients? Set that the protocol. What your command, alliance, alarm, take. And support the alliance up to support take. Take. Up to count up. Alarm, take. Up to that. Alarm, take. Right. Why the standard predictions that predicted state in life.
Your lordship will find the sentence at page 168. Because Sobur has been also convicted under 324 for 2 years.
The for life. The fine of the fee 5,000. On my default, arrive. On the other hand, Sopur was convicted under section 3 and 324 right. He was also Sopur Ali was also that was 7. Sopur Ali was also convicted under section 307. Sopur Ali was just sentenced to the federal sentence for life. The final 5,000 before arrive of the section 302. So was sentenced and the reduced for 2 years. The fine was a big 1,000 for my before arrive for 1. And the section 324. So for all the was sentenced for reduced to 8. The fine of 2,000 for my before arrive for 2 months. The section 307. The topic for the app. Topic for the that Kalam Sheikh was minor at the time of commission of as such, the issue of juvenile of Kalam Sheikh to decide because prior to deciding the submit that document that had submitted to the clarify for deciding the issue of juvenile of Kalam Sheikh having not been accepted by on the ground that applicated document. What did it say? It's all
Report, report was like it.
The exact word is used because bogus and fake, quote unquote bogus and fake. Which you have disputed, my lord.
And authentication test.
No.
And we conduct.
Yes. And we have,
Medical.
but I take your, we have also filed a IA against this report, madam. It's not in the record. Well, yes, madam.
If it-
We can give the filing number.
for the council. Submit. That for the sincere eyewitness. Dr. Ali B. Yes. Dr. Ali. Packet PW. And identify Kalam Sheikh as the person that depicted the floor with the dagger, the abdomen of the deceased Shahid Ali. And Sabur Ali as the person who depicted the blow with the knife on the back of the head of Shahid Ali. The report of the evidence of PW5 with the doctor who had first examined PW8. And the evidence of PW9
Page 88.
that examined
Page 88, madam. You will also find the injury on Bakar Ali.
but conducted the postmortem examination on the dead body of Saida showed that the Indian the staff of the so that there was no Indian the staff of after the it could not have tried to the action of Topura who had parents hit the back of the head of the with the that's all.
And page 59, the injury explained is external wound number 1 is simple. Because your lordship will find this injury number 1 at page 59. Quote unquote. It is on the front side, not on the back side of the head. Page 59, inside zone of sign present over left parietal scape located at midline above superciliary region. But that's if you are The superciliary ridge is the from the above the eyebrow.
The concept was that the post-mortem report dated 7/12/2020. Issued by
Issued by the ballot PW 9. The doctor at GMC, page 61.
that is R. Chaliha.
That is the civil charge.
And the out here, this is different.
Malad, the,
This one is Brindal Halloy.
Malad, because Malad, your lordship will see the postmortem report. This is the original, because yeah, it's Eddie. Yes, sir. Your lordship will see. Second.
R. Chaliha.
Actually has not deposed. He is the person who has deposed as PW9 is the forensic analysis, my lord. Your lordship will see the PW9. He has given his designation, madam.
CW9.
Yes.
He has done both mortem examination of the dead body
Yes, madam.
at page 98.
Yes, madam. Yes, madam.
But this post-mortem report has been signed by Dr. R. Chaliha
Yes, madam.
of PPP.
Yes, madam. PW9 is professor, he says Department of Forensic Medicine, GMC. But in that the prosecution ought to have clarified, my lord. And
You could have also clarified to that.
your lordship will find at the top Minal Halloy. Is there, hello. This Minal Halloy is there.
Where is-
Yeah, my lord. In the postmortem report itself. Dr. Minal Halloy, demonstrator, Department of Forensic Medicine, Assistant Surgeon of Medical College, Sub-Assistant Surgeon. Remarks, just above the remarks by civil servants above. On the right hand side, मतलब this one I mark it, मतलब I'll mark it by red. ये तो दिया है.
That's it. Just the issue, but that's the 2000. Regarding the loose position
Size and nature.
on the degree of I have detected a serial number 1 of external wound. External wound. Shows that the intelligence that has been located on the head of the feet. What on the front portion of top of the disc and not on back of the head of the disc. And that it is PWA, it is second.
Then
The top, that of the scalp
is only a contusion that at the bottom your lordship will.
feet.
At the bottom at page 59 your lordship will find. The injury at the scalp is simple because it is only a contusion of size 9 centimeters. Means it's not at this 9 centimeters. Because if your lordship include
Where is this simple?
contusion, abrasion are all simple injuries. my lord.
Now you have become a doctor.
No, not a doctor, but this is
But
common
please
knowledge.
read, don't put your own pin into the what they have said. If
No,
they
my
say
lord,
that it is blue, say it is blue. If they say it is black, say it black. Don't say it is black is pink or pink is red.
My lord,
We do not know that.
my lord, abrasion is
Anyway,
always
let me
simple.
have it.
Your lordship will see contusion of size 9 centimeters
Okay,
plus
please,
scalp.
let us not waste time. Have time. You're not
No,
given.
no, I was only trying to assist the court. When we say aberration, I need not say it is grievous. It is implied that it is simple. Your lordship may not agree with
You
me.
see, you see, I asked you where is it written?
No,
The
no,
word
this,
I used was where it was written. Now
So-
you should have said, it is not written, but this is the meaning that can be read into the.
that is what I intend to say, my lord. If I have not conveyed it, that is, that may be otherwise. But this is what I want to say, that since it is in the scalp, it is the condition of 9 centimeter and 4 centimeter, it is only a simple injury. It can't be.
That word was simple in this.
And my lord, the opinion, my opinion that page 60.
Mr. Counsel, enough. It's enough. There's a limit.
I could have avoided by taking adjournment, but I did not take an adjournment because I wanted to show before this honorable court. Yes, yes, that's fine.
According to the topic, that when the post-mortem report and the evidence of PW9 show that the kids have died, had not died due to any injury on the scalp of the kid. There was no agent for the damage trial for the convicted Procedural for causing the death of the deceased. In respect of, in respect of Kalam Sheikh, the learned counsel subject. The that applicant speak. Winner. Case of case of Kalam Sheikh Juvenile. Keep here. They didn't keep from our the other hand. That Private sector reading of the evidence used by the witness, especially the injured eye witness. And the post-mortem report read with the evidence of PWN. To go to show that in the opinion of the doctor, that the death of the deceased was due to hemorrhage and shock as a result of injuries sustained over the body as all the injuries were anti-mortem caused by moderately heavy from a double edged from a poetic tip snap cutting weapon. Just that when the evidence of PWA as categorically shows the presence of the applicant Kalam Sheikh and Sobura the time of commissioning of the crime. And he has seen them effect, he has seen the inflicting wound on the involvement of the death of the was there no credit for the for the according to the according to the section 89 or statement. It's not.
Quoted-
89, 89 to 430 billion. We have heard the learn of the evidence of PW is pretty very page. This is the extract of extract of the evidence of CWA with the injured eyewitness. It, it, it was part of the report, the Bruce position of a size and the color pertaining to the deceased, the postmortem report dated 7th of the or relating serial number 1 of external response to it not a bit the external of the top of the it took that there was an injury on the top of the it just got hit up to it that it was by Procedural was on the back of the head of the victim. That was hit exactly on the back of the head. The ankle and the man that the that of the position of witness have a bed that will have bed that will have it and even and back of the head and the height of the bed would also depend upon the position of person. Yes, but like that ankle position of the and that do not be type or apart. It and the postmortem report has it safety on the top of the head somewhere towards the back of the head. And that big and it was on the top of it in terms of the books of it or the book. The evidence of freedom of the night. It is not examined. The effect scalp was intact was to get the and that the presence of the surgical stitches meant that the disease was within take the pen. Careful. And examination. But he did. What the doctor and the fourth or the who wrote the fourth or the fifth. To the following. The following. Yeah, it's how the question of supernality of the landscape would have question of the Sudan of Sudan. By after the report, not the understand.
It was not ordered.
Your lordship has to direct the,
Where to that
oh, yes, and it has to be within a particular time frame. It has to be by a medical board.
order. The that by the applicant allow take care of the that take the report. That the result of after the director
By constituting a duly constituted medical board.
the superintendent.
No matter, it will be a medical board will be constituted.
By who?
The judge, the learned trial judge, district judge will
After the
direct for constitution of a medical board.
direct for constitution of a medical board.
For,
to- for holding a constitution.
no, the exact word will be for determining the age by an ossification
For
test
determining the age of the Kalapik.
by an ossification test
Of
or any other
medical.
or no, ossification test, or in the act it is written, or any other latest medical age determination test. So it-
Authentication test in accordance with. The report, should be made in the period of, should be made at the earliest and preferably in the period of. If we,
Or it's also insufficient. Only X-ray has to be given, they have to compare the X-ray if it is only ossification test.
I afforded.
Well, the copy of
I
this,
is
or-
accordingly.
well, the copy of this order may kindly be sent to the trial court. Because the person is inside jail. May I specify the name of the trial court?
Yes.
Additional session judge, Dhubri. We are obliged. ma'am.
Here's the fact that. the Office code, dated 25/7. That the office code dated 25/7. If I give them what could get it. Has been dated that office. But what does it state it found that trial court or the of the table. The madam.
Maybe. The primary this matter will take any other day.
Right.
Lordship, on part third matter is going on for number 6.
Our third matter.
Lordship. My senior is on that. Lordship. Probably it will take some time.
Yes, that is that. That is probably with
It's the IU Chaudhary.
I use
On
Chaudhary
behalf of referral number 2.
praise for statement on the ground that this city is on leg in another matter, in a part third matter in another. The case not being objected by the counsel for the appellate and the addiction with the matter
Any day. Lordship.
after a week or 2 weeks or 2 years or
After 2 weeks. Lordship. Yes, yes.
Right.
This case, my lord, before he started, I paid for the state of Mizoram. So I paid for accommodation for the day because I could not get charge the paper book and don't have any materials to prepare the case. Today I will make a copy from him. Next Tuesday,
he lost it again for 2
next Tuesday, 5th, Lord.
On faster, my lord.
Seven. Next week, Tuesday or Thursday, Lord. I will.
right picture.
A Borua,
A Parva, you can keep it.
Common Advocate Mizoram.
Yeah, give me the fee.
Yes, as a PP now. Here we are representing.
But yeah, that doesn't fit.
But there's no PP here in. is the-
That, yeah, people, otherwise, that is what we are after 50, they will say, better fit.
Because there is no PP there. Is PP. That is there. Here, in Goa.
That is for the,
My lord, this case, my lord, earlier, by way of an application, the Chief Justice of this principal said has accepted and take the jurisdiction of this case, for the case matter. And matter was hard, bail application was hard, and I am in bail matter.
no, that is all right.
That is-
So how does it matter? Let it go back there. This is a matter pertaining to Mizoram. We can ask the chief justice to take offense with it. Or ask him to, let it go back.
My lord, earlier he,
Huh?
they represented my lord, since last 2018. They represented me.
Why was it transferred here?
Because my lord, I was, when I was in jail, I was transferred from Mizoram to Assam jail, Sri Bhumipal. So my lord,
No. You had prayed for filing the appeal here. That's why.
because I am in jail in Korimganj. Because I got transferred from Mizoram to Assam.
Right.
My lord, since 2018, my lord, they are representing me, this case.
Represented by a person who cannot take up the matter. And there is a bench there. Have to take it up there, right? Right, Mr.
HR Chaudhary.
H.R. Chaudhary, Senate Council for the Appeal.
My lord, my lord, my humble submission, my lord, 2 days time may be granted, so that I can check it whether the earlier someone is represented, who is my lord, something, if you are additional advocate.
No, we're setting it to the chief executive. Also heard Mr.
A Borua.
A. Barwa. Leonard
government advocate
government advocate Mizoram, who submits that he is appearing for the state. Next slide. This is an appeal against the judgment and order dated
511.
5/11/2006, passed by the Court of the Additional District Magistrate, bracket A, as of in criminal trial number 870/2000 under section 30/201/376 bracket F IT. No, no, what about? No, no, 2000, comma, by which the appellant has been convicted under section 30 IP, read with section 201. And he has been accordingly sentenced to undergo rigorous imprisonment for life under section 302 IP and rigorous imprisonment for 10 years under section 201 IP. Next up. When the hearing was to be conducted, we were informed by Mr.
Table.
A. Barwa, government advocate, Mizoram, that he represented the state with the present criminal. When we asked Mr. A. Barwa as to whether there was any TP, fact AP to represent the state of Mizoram in the criminal, he stated that there was no PP tax criminal, PP tax AP to represent the state in this. We are of the view that unless there is a P or AP to represent the state, would not be proper. It would not be possible for us to hear the appeal. On looking for reasons as to why this appeal is listed before principal, when there are divided benches being held with the eyeball bench of the party act, we found that permission for filing the present appeal had been made before Honorable Speaker sometime on 13/3/2008, and the same had been filed. The note by which the present appeal has been allowed to be filed is the present in the principle, and the reason for it being in the principle is produced therein. That's all. Take it. Put the blue. Next one. On considering the fact that the case pertains an event that has occurred in the state of Mizoram. And the trial has been concluded in state of Uttar, we are of the view that the present plea can be heard by division bench if the eyes of bench of the court. If the present plea is transferred to the eyes of bench, the body. According to the
One of my submission, I am from Assam,
Huh?
taking an applicant from Assam, right?
Maybe
And the very
Maybe.
poor person, the daily wage earners.
legally work, legally can always be given. No problem. Legally can always. According. Registry to place the. Matter before. It's the. The neighborhood. The need to, so that he can take a final decision. That. As well, bench of the court, yeah. But
Public.
yes, Mr. Council, you can do virtually or. Virtually you can do.
Yes, meet reasonable. However, this is the jail kid wherein the appellant may have been found convicted under section 302. And I am appearing as an amicus for the appellant. The sole basis of conviction of the appellant is on the basis of his confessional statement. And there is no other eyewitness to the incident. Now, so the issue before lawsuit would be whether the procedural safeguard that is provided under section 164 has been followed. And if not, whether the confessional statement has any credence for the conviction of the appellant. That would be my endeavor to impress that the procedural safeguard has not been followed, for which the conviction is.
Let us see the FIR.
Yes, Silver. Page 4. On 12th of 7, 2018. Kumarigata Police Outpost. It was later forwarded to the Tamanpur Police.
This FIR is
Dated 12/7/2018. Your lordship can also see the details at page 1.
The informant is the brother.
Yes. May I read the FIR? Humble submission is that around 6 a.m. today, that is on 12/7/2018, my elder brother went to Senguni Bari Gaon to work as a laborer. He worked there for half a day, and after taking in wages, he did some purchases at the Bogajuli turning. Around 12:30 p.m., while he was returning home, the accused person, out of all grudge, brutally killed my elder brother, Kena, and left his dead body near a drain near Kala River under Chegunibari village. It is worth mentioning that for the last couple of days, the said accused has been threatening to kill my elder brother. Therefore, I request you to take necessary action in this regard. So on the basis of this, the FIR was registered and investigation was done. Ultimately, the charge sheet was filed under section 302 on the basis of evidence collected as well as the confessional statement. And the trial has proceeded thereafter. May I read the evidence of PW1? PW1. None of the witnesses are eyewitness.
They all hearsay. That is at page 9. I know the informant of the case. I know the accused present in the court today. I know the disease. The occurrence took place about 10 months back from today. On the fateful day at about 2 p.m. while the deceased was returning to home from his work, the accused attacked him by means of a bamboo stick at Shegunbari near Kalanandi by hiding himself behind a bush. As a result, the deceased sustained head injury and died. After getting the information from local villagers, I reported the incident to the local police. I went to the place of occurrence immediately. I saw the dead body of so with severe head injury at the spot. Police came to the spot and inspected the dead body by inquest report, Exhibit 1. Police sent the dead body for postmortem examination. The police recovered a bamboo post near the dead body and seized by the Exhibit 2. Exhibit 2 is my signature. Exhibit 1 is the said offending bamboo post. The police inquired about the incident from me. The police sent the accused to jail. One Manika Pandu saw the accused picking up the bamboo post from a house on that fateful day. It is a fact that I did not state to the police earlier that while the deceased was returning to home from his work, the accused attacked him by means of a bamboo stick at Shegunbari near Kalakandi by hiding himself behind a bush. I have not seen the occurrence. It is a fact that I did not state to the police earlier that Manika Pandu saw the accused picking up the bamboo post from a house on the fateful day. So this eyewitness is not an eyewitness. He heard it from the local people. PW2.
Matika Pandu.
Is PW4.
Huh?
PW4. I'll also come to examination where it is doubtful whether she saw the accused picking up the bamboo from a house. PW2. I know the informant of the case. I know the accused present in the court today. I know the disease. The occurrence took place about 10 months back from today. 3 days prior to the occurrence of the marpit, a marpit took place between the accused and the deceased at the house of the accused. On the fateful day at about 12 noon, local villagers informed me that the accused has assaulted Dina Soren by picking up a bamboo post from a nearby house. Accordingly, I went to the bank of Kalanadi and saw the dead body of Dina Soren. I saw head injury on the dead body. In the meantime, police came to the spot and made inquiry. One Manika saw the accused picking up the bamboo post on the fateful day. The police inquired about the incident from me. Exhibit 1 is the bamboo post used by the accused in the offense. I have not seen the occurrence. It is not a fact that I did not state before the police earlier that 3 days prior to the occurrence, a marpit took place between the accused and Dina Soren at the house of the accused. I did not see the said marpit took place at the house of the accused. It is not a fact that I did not state to the police earlier that the accused had assaulted Dina Soren by picking up a bamboo post from a nearby house. It is not a fact that I reported falsely against the accused that Manika saw the accused picking up a bamboo post. Such type of bamboo post like Exhibit 1 is found in every household of our village. This is important. I cannot say if the police put some mark or its measurement in respect of Exhibit 1. It is not a fact that Exhibit 1 is not the said bamboo post used in the offense. PW3. I know the informant of the case. I know the accused present in the court today. I know the deceased Dina Soren. The occurrence took place about 9 months from today. On the fateful day at about 12:30 p.m., while I was in my home, I heard human cry outside. Accordingly, I went near the bank of Kalanadi and saw the dead body of Dina Soren lying near a tree. I saw injury on the head and the face of the victim. I also saw a bamboo post laying near the dead body. The police came to the spot and inquired about the incident from me. The police seized the bamboo post by Exhibit 2. Exhibit 2 is my signature. A woman named Manika Pandu informed me that she saw the accused carried the said offending bamboo stick before the occurrence. Hence, we are of the opinion that the accused assaulted the victim by means of bamboo post. Later on, I heard that a quarrel took place, the accused and the victim 3 days prior to the occurrence. I told my wife, it was told by wife of the deceased. The police inquired about the incident from me. Exhibit 1 is it. It is not a fact that I did not state to the police earlier that later on I heard that a quarrel took place between the accused and the victim 3 days prior to the occurrence. It was told by wife of the deceased. Even this witness is not an eyewitness. when cross-examination, last part, I have not seen the occurrence. So it is denying the fact.
So everything depends on Monday for part two.
Yes, PW4, which we are going to read now, Your Honor. I know the informant of the case. I know the accused present in the court today. I know the disease, Hina Soren. The occurrence took place about 8-9 months back from today. On the fateful day, at about 12:01 p.m., the accused came from the market and took away a bamboo post from my house. At that time, I was sitting in the courtyard. This is important, Your Honor. I saw the accused taking away the bamboo post from my compound. Later on, public made hue and cry regarding laying of dead body nearby. Accordingly, I went to Kalanadi River bank side and saw the dead body of Hina Soren lying near a drain. I saw injury on the head and face of Hina Soren. I saw the bamboo post which was taken by the accused from my house was lying near the dead body of Hina Soren. The police came and inquired about the incident from me. Exhibit 1 is the bamboo post which was taken from my house by the accused. In the cross-examination, it cannot be seen anything towards my garden side from my courtyard. This is important, Your Lordship, because in the examination, she has deposed that she was sitting in the courtyard. And from that courtyard, the garden side is not visible. That's in the cross. It is not a fact I did not state to the police earlier that I was sitting at the courtyard. It is not a fact I did not state to the police earlier that on the fateful day at about 12:01 p.m., the accused came from market and took away a bamboo post from my house. And I saw the accused taking away the bamboo post from my compound. The offending bamboo was standing at the backyard garden of my house. So from the courtyard, the garden is not visible, and she was in the courtyard. So it is not possible for her to see the victim. And PW2 has already stated that these bamboos are available in every household. It is not a fact that I had deposed falsely that I saw the accused took away the bamboo post from my compound. It is not a fact that I did not state to the.
But then how do you know? They might know which good bamboo.
Exactly.
Everyone has got a cake. No bamboos are the same. See, every photo village, every household, forget the village, even in the town, my house, everyone has got a knife down. And I will know my down. If you put 100 down in front of me, I will know which one it is. Doesn't mean that every thing or every down will be exactly. There's always some different.
Yes, if it was a bamboo stick, then I would understand what is falling from your lordship. But here, it is a grove of bamboo which was uprooted. The Caesar list will see, and from the IO also it will come. From a grove of bamboos, if you uproot one, it's difficult to identify it is that particular bamboo. These are similar type of bamboo grove where every household has. It is not one stick.
That's not it there. That's the biggest problem.
It will come later, Your Lordship. Because he says it was taken from my compound. It was uprooted or not because
You see, you cannot uproot a bamboo. Let me be very careful. A bamboo is, you see, if a bamboo pole or bamboo stick around like this, stick.
yes.
It depends. Just because uprooting it does not mean that it is connected to the ground. How it roots and all.
Then may I
Can be already a cut bamboo. It's been described.
yes, this is described in the Caesar list at page 69. Yeah. Page 69 has a diagram.
Yeah.
Because description is very clear. One bamboo with root, length total around 5 feet 6 inches, diameter 7 so. Root portion length is 2 feet, stem portion length is 3 feet 6 inches. And the description here, the diagram.
Have you ever tried to for the bamboo?
I look in Assamese, we call it Pahar Puhan.
there are two things. One is demo board, that has to be cut. The demo has said, we use it as a fencing or whatever. Then Bahar Mohan, then we pull it out from the root matter, it will become root. That big portion, it will also have been a demo, I am sure. There is a round portion behind the demo root. That is called Bahar Mohan in a family. Sometimes we kept in the compound. Because to clear the garden or to here.
Very hard to put. Have you ever tried to put?
But not necessarily the whole, right? Along with the little portion that is called the bamboo
The
mohan.
diagram is also given, your lordship.
Bahar moha, that is called an estimating. In fact, when some people used to make it a wall in village area to play cricket.
We eat the bamboo, so you always look out for which is eatable, which is not eatable. And you're going to use a knife.
And one important aspect of this evidence is, your lordship.
That is the medical report.
Yes. Medical report is, your lordship. Yes, page 71. Or your lordship can see the page 22 is the evidence of the doctor. Page 22. Wait. May I read, your lord?
Yes.
On 13/7/2018, I was posted at RV Civil Hospital at Mushalpur, and on that day at about 1:30 p.m. I conducted postmortem examination on the dead body of Hina Soren, aged about 40 years, male, so with reference to Soren's identity. Second paragraph. A healthy dark complexion, male body wearing black Indian danio with a traditional cloth, mouth semi-open and eyes closed. Rigor mortis present, body with blood from mouth and nose. Injury, 1.5 inches diameter injury with irregular margin over left aspect of the forehead. Left aspect of the forehead, lordship, something from the hairline to the eye, this side of the. An injury over left upper eyelid and 1.5 inches length, lacerated injury below lower eyelid with damaged eye, same side caused by blunt object. Bruise around the injury marks noticed, which is due to trauma by blunt big stick. But the injury around the left eye due to sharp object. Fractured of frontal bone on left side. So frontal bone is again this side. So injury is basically on the left side of the, between the hairline to the eye. Following tremendous hit over there. Damage of brain on same side where blood clots seen. Opinion. The cause of death is due to hemorrhagic cardiorespiratory arrest as a result of homicidal head injury. The time since death is 25 to 26 hours. Exhibit 3 is the postmortem. Exhibit 3.1. It is due to basically a trauma caused by blunt big stick. Process is not the fact that the injuries or detected on dead body can be occurred due to falling on hard surface. But the clarification is there. It's not caused by falling. The IO did not give me any indication regarding the weapon used for causing such injuries on the dead body. My opinion is based on presumption. May I read that and witness, court witness 1, your lord, because other witnesses are all hearsay witness who had not seen the incident. They have all gone to the place of occurrence after hearing about the incident. So basically his conviction was on the basis of confession statement connecting with the injury. Because the injury is caused by the informant with PW. Court witness is the informant is PW. Informant is 6. Marisa Soren, 6. Lordship may written PW 6. PW 6. Page 19, Your Lord. I am the informant of the case and filed the ejahar of the case. I know the accused present in the court today. I know the deceased Tina Soren, who is my elder brother. The occurrence took place about 10 months back from today. 2 days prior to the occurrence, a quarrel took place between the accused and the deceased. Thereafter, the accused told me that he will kill the deceased. On the fateful date around 6 a.m., the deceased went to work. After completing his work, the deceased was returning home at around 12 noon after visiting the local market. But on his way home, the deceased was assaulted physically by the accused near the bank of Kalanadi by means of a bamboo pole. As a result, my elder brother died. Local villagers reported me about the incident at my home. Accordingly, I went to the spot and saw the dead body of my elder brother with head injury. Police in the meantime came to the spot. The police sent the dead body for post-mortem examination. The police arrested the accused. The police recovered the offending bamboo post near the dead body. The police inquired about the incident from me. I have no personal knowledge regarding time of returning of the deceased of his work. I have not seen the occurrence. It is not a fact that I did not state to the police earlier that 2 days prior to the occurrence, a quarrel took place between the accused and the deceased. And thereafter, the accused told me that he will kill the deceased. This has been consistent throughout other witnesses also. So now, PW2 says these bamboos are found in every household. Though the PW4 says she saw the accused taking the bamboo from her compound, but she was in the courtyard. The courtyard is not visible.
Was it he?
It was seized, but there was no examination of fingerprints or the blood stains, nothing to connect to the disease. So whether that was a particular weapon lifted from the compound, when there is no clear evidence that she could have seen the accused, it creates a doubt, and no one has seen the accused at the place of occurrence. So only thing which falls back is the confessional state.
What's wrong with the confession?
He was not given assurance that if he does not give the confessional statement, he would be provided protection from the torture or pressure from police. This is one of the mandatory requirements. Because for the confessional statement to be free and voluntary, that assurance has to be there. He has to feel safe and secure that if I don't give the confessional statement, I will be provided protection from pressure or torture from the police or other authority. If that is not given, there can be no deduction that the confession was free and voluntary. If that be so, then whether the confessional statement has any credence for conviction of the accused. In that regard, if the lordship wants, I'll just go to, I'll read the evidence of the court witness as well as his confessional statement, which is exhibit as exhibit 5. Then I may place my judgment.
Whether say that assurance has to be given.
It comes from the judicial grounds. Because here the requirement is that upon questioning, there has to be an inquiry regarding his, whether he has made it voluntarily, free from fear. That inquiry and satisfaction has to be there from the magistrate recording the confession statement.
Questioning that them,
Sorry, Your
but can they will be there?
question. There are two aspects. What if he's reading exhibit 5 or questioning regarding that if he does not give the confession statement, he would be provided protection.
With the form you
Form, Your Lordship, I tried to find out. It is a form 8, form 92 of Assam Schedule 8, but I couldn't get hold of it. But the exhibit is. But what are the questions that are to be put? The
but it, yeah,
53. Yes, they've put other questions. Yes.
if it's there. That assurance has failed.
Question M, Your Lordship. And question M is
It is here, the top. L is the top.
Lordship is reading from his evidence.
Eternal page 20. Up to that page.
Okay. You was given assurance regarding that you will not be sent to police custody.
Yeah.
But that is the second part of the requirement. The
Ah.
first part of the requirement is that you will not be, you will be provided protection from police torture or pressure if you don't give. That is also one of the mandatory requirement.
Must give us the censor to put it at the table. That is the.
Then-
It is here off.
Then I may just place one judgment because that is my only argument otherwise. Otherwise, other complaints are there. He has been given enough time for reflection. In fact, 3 days in judicial custody. Then also 2 hours before the magistrate. The other complaints are there. This is my only ground. So in that regard, may I place one judgment, Your Lordship? Discusses in paragraph 53. Paragraph 53 discusses the entire, all the previous judgments on the confession and what are the requirement of confession. I'll just take your lordship to the relevant part. Paragraph 57. Paragraph 57,
Yeah.
it says, it quotes paragraph 27 and 28 of the judgment. Paragraph 28 is 516. It starts at paragraph 57. Paragraph 28, your lordship. Next page, 516. It has also been held that the magistrate in particular should ask the accused as to why he wants to make a statement which surely shall go against his interest in the trial. he should be granted sufficient time for reflection. He should also be assured of protection from any sort of apprehended torture or pressure from the police in case he declines to make a confessional statement. And paragraph 58, somewhere in the middle, at the other part which is the lordship had asked will become clear in paragraph 58. Yes, paragraph 58. Your lordship query will be answered, I hope, in paragraph 28. Paragraph 28, it goes paragraph 6 of the judgment. And if your lordship may turn to the next page. The last line, the content, it starts at B, placenta B, section 164. The first paragraph itself, B, next to B, section 164. Section 164, namely that the accused is not bound to make a statement and that if he makes one, it may be used against him as evidence in relation to his complicity in the offense at the trial. That is to follow, he should also, in plain languages, be assured of protection from any sort of apprehended torture or pressure from such extraneous agents as the police or the like in the case he declines to make a statement. And be given the assurance that even if he declined to make a confession, he shall not be remanded to police custody. So in my humble submission, there are two requirements. One is he should be assured from protection if he declines. And second is that he shall not be sent to police custody if he declines to give confession. In my humble submission, here, the second part is complied with, the first part is not complied. In that case, whether the confession can be said to be voluntary and free from fear. If not, then the confessional statement is not a worthy, it does not give credence to the evidence for his conviction. Because if your lordship may turn to the previous page, page 1516, the same judgment which quoted, somewhere around F, paragraph 58, F, full and adequate compliance is not merely informed, but in essence, with the provision of section 164 CRPC and the rules framed by the High Court is imperative, and its non-compliance goes to the root of the magistrate's jurisdiction to record the confession and renders the confession unworthy of credence. Ultimately, your lordship, it was summed up in paragraph 64. After going through all the judgment, paragraph 64, they sum up. I'm relying on 5. He should be assured of protection from any sort of apprehended torture or pressure from the police in case he declines to make a confession statement. And so
that portion is not there.
that is there in the
Then
judgment.
if it does not make, no, it is
Yes.
para 64.
Yes,
That the second portion is not.
but there in the previous one, they're relying on that judgment and they're summing up here. And your lordship may also read A.
So basically, that is the summing up portion of the judgment. There's That all of that.
I would not view in that way, Your Lordship. I would say the twin requirement is very important.
But that is not mentioned in the challenge. It is equally important. That second portion should have been there.
Yeah.
Okay. Anything else?
Because also one more thing, Your Lordship, there's another finding here that they should record the reason. The judicial magistrate has to record the reason so that it can be examined by the higher authorities while taking into account whether because it cannot be a subjective satisfaction whether the confession is voluntary. One has to ascertain in the objective way because it's very difficult to ascertain the state of mind. These are the questions, guiding questions, which is made
What is
mandatory.
the bad for certificate?
It on solely on the basis of judicial confession without any other evidence also a person can be convicted whether when the mandatory conditions are fulfilled and one can ascertain that it is made voluntary and freely. If not, then it cannot be the basis. Then one has to go back to the other evidence. And in this case, there is no eyewitness. Even the seizure weapon is doubtful. PW4 statement is doubtful. On the basis of that, whether the accused can be convicted. That is my.
Whether this,
Yes, it was treatment. Yeah. While framing of charge also at this time of 313 also. Because he pleaded not guilty while the charges were explained as well as in 313. That is all. Otherwise, repetition.
what is the profit?
More. Right. It's from the date of judgment, it's 3 years, 8 months, but I was arrested on the date of incident itself. So that is on 12/7/2018. I think there is no record to say that I have been granted bail from that day. So 18.
Well,
Yes, I don't.
And
just, I have to get it perspective.
Yes. My lord, going by this, my lord, first of all, my lord, I find that that is has been reported not properly. The thing is that my lord, no kindly see. He was initially produced on 13/2. That was sent to judicial custody. So there, aspect negates the fear of, but he was been before the judicial custody for 2 days. Thereafter he came, then sufficient time was given for reflection. Then those questions were put.
No, I'm not on that.
That thing,
I'm not on that.
my lord.
When
but
you
there
read
is-
his confession, supposing we accept his confession to be true,
Yes,
his confession does not indicate that it was premeditated. Will it come under 302?
Well, then there are witnesses, his wife, PW 5, PW 4, 2. There was a quarrel between them prior to the to this. That aspect has not.
No, it's not like that. What a fact thing. The conviction is based on the confessional state. Correct? Which has been retract.
Right.
Now, assuming that we have to convict him on the basis of the materials that are there
Right.
against him in his confessional statement. Does the confessional statement say that it was a premeditated murder?
It doesn't seem so.
Homicide, huh?
It doesn't seem so.
Doesn't seem. So can we take only a part of the confessional statement and convict him and leave out the rest, which does not show that it was an intentional case of murder?
It has to be taken as a whole.
Huh?
It has to be taken as a whole.
If it is to be taken as a whole, would 302 be affected?
And otherwise, my submission will be clear because from going by the evidence, while it seems he has a motive, he has a because there was fight between them and PW4 my God. He said my God that bamboo pole was taken from her place. Then he assaulted him. Regarding my lord, that fight, that evidence has not been discarded, but they
Look, in normal circumstances, the bamboo pole does not kill anyone.
my lord, the size of the bamboo pole, it
So
can
what is the size? What is the size?
come to the civilians.
What is the size? You see, it is talk about what is the girth? What's the girth size of the pole? Then it's 5 point something.
Yes.
That does not mean anything. Depends upon how big, how sturdy.
5 feet 6, quite long,
It doesn't matter. This can be any can
my lord.
If it is this thick, understandable.
My lord, kindly
What is the girth? Size of the
diameter around 2 inches,
width?
root portion length around 2 feet.
Not
Well,
radius. Diameter.
Yes, because
No, diameter means what? The entire round.
no, that is my lord,
Entire.
Entire round will be how much?
2 feet, same portion length around 2 feet. My lord,
You see, when we were it, at the post, the thing was that Malacca case. Malacca case was it's a bended type. And it used to sting a lot. And they hit us with force in our pato. That did not kill us. If they had hit us with a big stick, with a full force, then maybe we would have broken bones. So it depends upon, now supposing you want to go and hit somebody. Let us just think normally.
Yeah.
Supposing you want to hit somebody, your enemy. You go with this long stick. Hey, it is this hit. Anything will happen. If you normal circumstances, it shouldn't hit. But if you go with this long stick, this stick, then probably it could have some broken. So it will depend upon the size of the gun.
my lord, here what is happening, my lord, may kindly produce this 59. As I earlier mentioned, my lord, we have to call it Bahamuha because that root, my lord, I don't know whether the picture is clear or there in my paper book, my lord. My lord, may kindly see the root portion. This generally is the, my lord, it's a very hard one.
Root,
Hard one.
usually,
Even
you see, I have cut number of bamboo during my lifetime. You see, going to the forest here. I have to chop out the root part. In fact, I have never been able to uproot a bamboo with all its roots. Very difficult. I don't know how they have done.
well, here we
Must be
do usually here we do, my lord.
with the bamboo,
But yes,
with the
pull
root.
it out, my lord, yes.
with the root.
Anybody can from place they can
Is
verify.
it bamboo
We call it Bahamuha actually.
with the roots?
Yeah.
You just pull it out.
Not as a whole, but that portion, man. We pull it out. Yeah. Of higher purpose.
Small,
Small portion.
small bamboo, not the big
Sometimes-
bamboo.
But it's very hard. It's very hard.
You can put it up like that.
Yes, it's very hard and the portion is very hard, very tough.
And so you go to kill someone with a bamboo with all its roots hanging.
Well, because the bamboo tree, that is 5 feet.
And
That might have,
with the roots hanging. Is it, it's going to
That's the-
use a weapon. You can't
Shit, maybe what you want to teach him a lesson or something, but about killing, that part we are out.
well, because that was already flying in the house of PW4, my God. That's already uprooted.
already approved.
Already
Okay, it's not approved
Yes,
from the
big
side.
number. Because I
already
kindly
uprooted.
see that the bamboo portion is 5 feet.
So he could have taken a knife from his house or a bamboo, his own bamboo. Why should he take somebody else's bamboo? They're also with the root.
But he could have, but
Or
because
he
it is
think that,
sufficient-
okay, I will use the top portion for hitting. The roots I will eat later on.
No, no, well, that lordship which your lordship is telling that is bamboo shoot. That is the initial portion. So otherwise, that portion is very hard.
It is 164, perpetual paper. Yes. Page
Page 79.
79. 79. What does it say out?
Well, his relevant portion, it's the start 79 and the relevant portion is 84.
84.
84.
Yes, please.
On 9/7/2018, on Monday, a quarrel took place between Hannah and me. He admitted it. Hannah Soren injured me and my wife, assaulting us. That was prior to the incident. On 12/7/18, Thursday, while I was returning from market, I met Hannah Soren on the bank of Kala River. Hannah Soren again threatened me and assaulted me. A bamboo was lying near the place of occurrence. I dealt 2 blows on the back and on the back side of the Hannah's head, and that piece of bamboo. He immediately fell down and ground and I left from there. Later, I came to know that Hannah was lying dead at the place of occurrence.
So does it show that there was any premeditation in going and trying to kill this disease? There doesn't seem to be. It seems to be a chance meeting.
Fine.
And then he was assaulted. And then he retaliated. So can it be a self-defense?
Well, that assault portion has not come in.
No, or can it come under exception 1? Grave and sudden provocation. No, I know. Again, threaten me and assaulted. He was assaulted first.
But that portion has not been proved.
But he's proving it. Who has been proving? No
Well,
one,
that has
there's
to be
no
proven there.
eyewitness. And then if you really wanted to kill, why wait for 3 days? 9 July, 10 July, 11 July, 12 July.
Grave and sudden provocation, if it comes, but then it will also come that because the amount of force, not proportion. Because the victim, as he stated,
No, you see, that will depend upon the weapon used.
Picked up whatever he
He,
found.
he picked up a bamboo stick. There also a very thin bamboo stick.
but otherwise, perhaps that portion, the very hard and very strong one.
You see, have you seen TV? CRP and the police and all with bamboo, they're chasing protesters with bamboo stick and thicker ones. If every blow was to kill, how many protesters would have died by now all over India?
It will depend upon the area in which they can. So it has assault against that.
So you have been in jail since 2018.
And otherwise, apart from these, the other witnesses also corroborated this confessional statement, like the area of dead body where it was lying, the injury. He also stated in his confessional statement that the other witnesses also corroborated. Maybe they are not eyewitness to the incident, but they went there and saw the dead body and saw the.
No, I'm saying, assuming that, okay, there was a killing.
Right.
But would it amount to murder?
Going by the assault method.
Because if you see, he was assaulted first. Unless you have got evidence to show, no, he was never assaulted.
He was assaulted first, but the thing is that, my lord, he was not assaulted that manner, even assuming this aspect, my lord.
We do not do so.
Why not? Because he was at his home while he was arrested. He was not, he never went to any doctor or never went to any hospital. Even assuming he was assaulted by him. And he assaulted with a bamboo pole in his head. And going by the medical evidence, it's not a single blow. It's not a single injury.
Medical evidence shows what is the
And it had been 9 months.
Where is the medical report?
Report is otherwise page 71.
Page 71.
All on the left side.
Several injuries.
Okay, so
Page 72, large portion fracture of frontal bone. Left side following tremendous heat over there. After the tremendous heat, my lord. Damage of brain on same side where blood clots in. Next, membrane damage on injury side. Brain, clotted blood over left aspect of frontal lobe notice. Then page 74, below portion, my lord, injury. Injury over left aspect of forehead and lacerated injury below upper and lower eyelid left side.
any citation?
Yes, madam, so far he has rejected his perfect. Whether that can be taken. And if it is taken, or not. That is taken.
Yes, para,
Para 6.
para 6.
Page 6 here, it is not para, I have picked up for people. Page 6. Last para. Page number is written below.
Yes,
Last put. The foremost among the factors that are thought to be relied upon by the prosecution is that rejected confession of the appellant recorded under section 164 CRPC the confession has been extracted supra in verbatim. Before acting on a confession made before a judicial magistrate in terms of section 154, the court must be satisfied first that the procedural requirement laid down in subsection 2 to 4 are complied with. These are solitary safeguards to ensure that the confession is made voluntary by the accused after being apprised of the implication of making such confession. Looking at a confessional statement so and so, it is not required, my lord. Next paragraph, my lord. Having thus reached the finding as to voluntary nature of confession, the proof of confession should then be tested by the court. The fact that confession has been made voluntarily, free from fear and inducement, can be regarded as presumptive evidence of its truth. Still, there may be circumstances to indicate that confession cannot be true wholly or partly, in which case it loses much of its evidentiary value. In order to be assured of the truth of confession, each court in a series of petitions has evolved a rule of prudence. The rule is the rule of prudence, that the court should look into corroboration from other evidence. However, there needs to be corroboration in respect of each and every material particular. Fourthly, there should be corroboration so that confession taken as a whole fits into facts proved by other evidence. In substance, the court should have assurance from all angles that retracted confession was in fact voluntary and it must have been true. The law of subject retracted confession has been succinctly laid down by the three judge bench of this court in Subramania, Hometown versus State of Madras, which lays down below. The next question is whether there is corroboration of confession since it has been retracted. A confession of a crime by a person who has perpetrated it usually the outcome of penitence and remorse, and in normal circumstances is the best evidence against the maker. The question has very often arisen whether a retracted confession may form the basis of conviction if believed to be true and voluntary. For the proposal arriving at this conclusion, the court has to take into consideration not only reason given for making the confession or retracting it, but the attending facts and circumstances surrounding the same. It may be remarked that there can be no absolute rule that a retracted confession cannot be acted upon unless the same is corroborated material. It was laid down in certain cases, one has been the showing proof. But basically, it can be relied upon, and the corroboration is required, but that corroboration is a rule of prudence, but not each and every aspect has to be true. My lord, then next paragraph, my lord.
No, please read the entire thing.
My lord. In Kesava Pillai, that if the reason given by the accused person for retracting confession are on the face of them false, the confession may be acted upon as it stands and without any corroboration. But view taken by the court in more occasion than one is that as a matter of prudence and caution, which has sanctified itself into rule of law. A retracted confession cannot be made solely on the basis of conviction unless the same is corroborated. One of the latest case being Balbri Singh by the state of Punjab. But it does not necessarily mean that each and every circumstance mentioned in the confession regarding the complicity of the accused must be separately and independently corroborated, nor is it is essential that corroboration must come from facts and circumstances covered after the confession was made. It would be sufficient, in our opinion, that general trend of confession is substantiated by some evidence which would tally with what is contained in the confession. The learned just then highlighting the difference between retracted confession and the evidence of an approval. Initially, that difference has been discussed, my lord. That is not required for our case, my lord. In that paragraph, fourth line from below. In the case of the person confessing who has resiled from his statement, general corroboration is sufficient. While an accomplice evidence should be corroborated in material particular. In addition, a court must feel that reason given for retraction in the case of confession are untrue. My lord, in parallel, the same principle in regard to evidentiary value of retracted confession has been repeated. Supara speaking for four judge bench, that is the legal position. A retracted confession may form legal basis for conviction.
What was the reason for retracted?
Here the reason they have not mentioned in Juvenile. In fact, he totally denied that I have not made it.
I thought
Wait.
Is that blanket denial that you have not made?
He is not made, but that is hotel denial. That is my lord, because that is not true because he has signed it, my lord. He has received it for read over to him. So there is no reason. And my lord, my submission is that that rejection is in a belated state. Belated
But
rejection,
it can be retracted.
it can be
Can-
rejected.
Can I application for retracting a confession fee?
No, I'm in a different footing.
No, no, it can, I just want,
No, it can be,
can be rejected.
it can be.
So after, if he wants to retract it.
There is no bar.
It can be,
No, that is
that's
not
what
a.
I'm asking.
Yes.
If a person has given a confession and he wants to retract it.
Yes.
And supposedly something happens. And the court said no. You know,
No, I'm not saying, I'm saying because he has repeated in a delay state, what is the evidentiary value of that?
so anyway, so basically part of the confession can be. Correct. Even if it.
There are other factors.
Take it up.
Yes.
I thought this was the last.
Mention for adjournment. So item number 10.
Item number
10.
10, 10, 11, 12.
That's it.
Huh?
Well, answer is, seeking adjournment in item number 10, 11 and 12.
I'm for the 10.
So it is all, it is
Connected
all
with
stacked
this one.
together.
Yes,
So if we adjourn one, it has to, I think,
yes.
My lord,
all others have to be adjourned.
yes, all together has to happen. So, my lord, tentatively 12th August, my. There was a two-part, my lord. First part, he has covered the sentence. The second part is the life imprisonment. That has to be looked into, my lord.
So basically the entire case has to.
Yes, my lord, that's, other part is, my lord, he has served the sentence.
And he has served the sentence.
Sentence, 2 years jail, he was there.
Ah.
Already there about 3.5 years. So other is 302.
Yeah,
That has to be looked into, my.
302 has to be taken.
Yeah. So that's why there's the urgency. my
All
lord,
of them
that-
are 302,
302,
all of them.
all of
Eyewitness,
30 my letter. But this is no, but the not seen together, but it's only oral manner.
Yes.
Only oral.
what do you mean oral?
My lord, they have say here's evidence, I say. They have not seen how he is died.
Extrajudicial conflict.
Yes, how he has died, nobody has seen. Only for the slapping the boy, he has been convicted under some section. So that is so 10th August, 12th August. Hmm?
No, 8 तारीख है ना, no.
No, 18 not. After 15 August. After 15. So we take it.
Can it be on 18, okay?
I don't know, it depends
Hey,
upon
TV.
your, there is a, you'll come out with a cause.
By August.
The September, first week of September.
On the prayer of the, on the prayer of the council for the appellant. The matter that then till
It's September first.
Second, first, second September.
second.
Second September.
The thing is that
Second.
because the motive has been that photograph. That is what I was talking about.
Okay, that's not the root.
That is not the root thing. It's above the
bulbous head.
Yeah.
Operating thing. It,
But here, since probably my learned friend has not raised the point that whether he has been given time for reflection regarding that there is no good, I think.
he said that time for reflection
Yes,
has
sir.
been
So I only point out here, paragraph 51.
50,
One,
para 51.
paragraph 51, page 451.
It,
My note here, another circumstance which reinforces the conclusion about the confession being voluntary is that it was not retracted at the earliest opportunity. The confession was recorded June 14, so trial of the accused comments on so when the charges were framed, read over, explained so. And at the trial, he was defended by so, who was an experienced lawyer. Trial drag for several months
so when was it retracted?
during the
Sure.
Actually, as I submitted my not retraction, he totally denied that I have not given.
Here, it could be denied.
Totally denied, I have not given.
So that is false.
That is. So this point also, this part portion, another that the earliest opportunity it is denied. It's the earliest opportunity it is denied.
He got wife. They learned.
That is there.
The thing is, the issue is whether 302 can be said to be a successful. That's the only.
But here my humble submission is that might not clear the force, the amount of injury and the part where he had, because that injury is not from a single blow. They have
Maybe. But won't that issue come up with regard to whether it will be under 304 part 1 or part 2? Not with regard to 302. 302 requires premeditation. There out here, there's nothing to show that there was any premeditation.
Like, here, but now that's my what is case law. But here also they try to take the benefit of acceptance. But here the injuries were in the vital part. So I could take out only one trick from them. The attacks were on vital parts of the body, and therefore we have no hesitation to holding that accused committed the act with only intention to causing death of the victim. I look here, nine. This man will committed. He has committed. There may be a fight, but he knew. He has the knowledge that if I hit this person with this bamboo in his head, he will die. And I think how much
Theoretically, he will be called, but I knowing that he will die, though I don't.
because my lord, the injury, if you let go to the injury, must have been caused by a several blows.
It depends. Sometimes just by a blow to the body, with your face, that can cause death also. As has happened in that cricketer's case. Now, in the normal circumstance, no one would think that that kind of a blow would kill somebody, but it did. So out here also, it is lucky charge, so many lucky charge with thick lathis. If people would have died normal for from a lathi charge, I then how many would have died by? But you don't see. Out here,
But really those public health where really it is treating the body in the not in a good one.
No, no, no. Sometimes you see them blood streaming down from their, you don't see photograph, blood coming out from their head, bandage head and all their got. Or what? Blood is coming out from their feet, but they bandage their head or something.
But
So it does. What I'm trying to say is that doesn't mean that every time you get hit by a bamboo, someone dies. It usually doesn't happen. It usually happens that they suffer some injury, but usually it doesn't take away life.
I know. But this portion is and that bamboo stick and this
And let me
portion is
tell you
different.
something: to hit a person on the vital part, we cause death. You should have, you require some practice. Have you played hockey? You- or cricket? You want to hit the ball over the boundary but get caught. So same thing with how you try to play tennis, you play badminton, you play any game. You need to have practice to be able to hit exactly where you want. Especially in a fight. Unless they are going to put their head like this, yes. Directly wait. I'm waiting for you. Give you 2 seconds. Hit me here. I won't move. Then only maybe you can do it. So I do it other.
But here otherwise apart from the
head.
apart
Then
from head injury there was otherwise no injury.
Huh?
Apart from head injury, yeah.
There
otherwise
was 2 injuries only.
yeah, those are on head this portion. But the thing is that so it shows that he could have hit him in other part also.
But he was also hit first. According to him, he was assaulted. Remember, there's no eyewitnesses.
Yes.
Only basis is the perfectional statement. And this felon has said that he was hit first. Now, can you say, no, he was not hit first? Can you
Taken
say?
as a whole.
You have to accept that. Anyway, right. The next one, you're ready.
But then
No matter.
my learned friend also took out the point that my but that recovery regarding that bamboo pole was not sent for FSL and all. So regarding just one
Yeah.
point. I mean, there are also I'm reading. There are also several lapses in the investigation of the case, like non-recovery of empties fired from the gun from the deceased, non-recovery of firearms used by the respondent, etc. It is well settled that any omission on the part of the investigating officer cannot go against the prosecution. That is, like if the investigating officer has deliberately omitted to do what he ought to have been done in interest of justice, it means that such act and omission of investigating officer should not be taken in favor of the
Unless some prejudice is caused.
yes. It is minus para 20.
So you all are ready for the POCSO matter? The appellant? You all are ready, no?
But if we don't have.
You don't have the paperwork.
They are taken by some officer.
Otherwise, you don't keep on me. And
And POCSO matters, so there's hardly any escape
yes,
route.
here this case actually I have not found any. If you can take up the.
I just read up.
Para 22.
20.
Present for the informant, then I will go through the paper book of I'll understand. Okay.
I just have 2 points. Just 2 points. And prolong that.
No, you see why I'm asking is either I dictate the judgment or I ask my brother to dictate the judgment, then I dictate the next judge. So that is why if you all are ready, if you are not ready, then I'll dictate. You all are ready, no?
if your lordship permits, just one point.
Yes, yes.
Yes. Okay, I'm given a judgment, 2009 SCC, page 1, regarding a blow by Danda on the head. That is 304, part 2, paragraph 14, your lordship. Because the weapon is such that there cannot be any intention. Knowledge, because on a vital part, though, yes, on a vital part, right, but one cannot infer intention because of the weapon used. Paragraph 14, your lord.
Yeah.
I'll read your lordship. Or and here, the confession, if you like, the lordship has come to us. One is transmitting, one is provocation, to falls
Oh.
under exception. Exception 4 of 300. And page 24, your lordship may just note down 29. That point, I don't know if I am able to satisfy your lordship. 29. That is a cross of the court witness. Very,
Page 29.
yes. This is a cross. I have not intimated to the accused in case if he denied to make confession in the case, I assured him protection from apprehension of physical torture by police. But that assurance was not given, he admits, and that is also.
I have reported the reason for confession by the report.
I'm relying on the first part. He has not given the assurance of protection.
But I think, you see, because that, the second part is somewhat connected to this first part of protection. That is why when they formulated those points, we did not mention the second part, but the first part, the second part of.
That's my argument.
My lord, this is the form prescribed by the rule of this court. The magistrate has to follow that form only.
Which is the form.
That form, the recording is not clear.
That is what is reflected here, but let us see the form and clear.
It's maybe the. Okay. Holding.
And regarding the point of the breakdown of the prosecution, if there are other evidence value, ocular evidence, here there are no evidence. The mother weapon is also not identified as such. The mother weapon is not being connected with the incident because it's not being connected.
Well, it's see.
It was seized, but no one has identified. The accused has not identified under section 27.
That response, that PW5 has not identified that.
Because they were not even in the place of occurrence. So everyone has assumed, the word used was, they were presumed that this bamboo was used, presumption was. Yes, if we use the confession statement, yes. But if your lordship is satisfied with the first argument, then there are no other evidence.
My lord. There is one general rule when I forgot the name, when I try to find it out from the registry also. That rule we could not get it. There is a high court some criminal rule.
Rule 25, but I couldn't find it.
I could put that.
That is the form to be used.
Yes,
Oh, perfect.
it may be in the criminal court rule.
Yeah, this is the form
It's the form made by the High Court.
as per rule.
Okay.
My lord, that topic name I forgot, my lord. That is from the high court criminal sub rule. Try to find out, my lord, could not get it.
I close,
Ah,
I close my submission.
thank you. Now we can start. Okay, right. Third picture,
Arshal.
I Karma, Learn Council for the. Learn American Spirit. for the appellant. Mr. Michael Good and Mr.
Arakut.
Arak Murthy, Leonard Kitchen speaking. Anybody for this person? This appeal has been filed against the judgment dated 25/11/2022, passed by the Sessions Judge Paksa, Kuchalpur, in section case number 20 of 2009, by which the appellant has been convicted the section 30 and sentenced on the book. This section
Page 34A.
the sentence to undergo rigorous imprisonment for life with a fine of ₹1,000 or for further rigorous imprisonment for 2 months. By sentence order dated 26/11/2020. The counsel for the appellant submit. No, the prosecution case in brief is that FIR dated 12/7/2008 had been submitted by PWC, who is the brother of the deceased, before the in-charge Kumari Kata Police House. Stating that his deceased brother was killed at around 12:30 p.m. while returned home. By the appellant on 12/7/2000. The FIR stated that the appellant had been threatening to kill the deceased for the last couple of. Pursuant to the FIR dated 12/7/2000. The police station in the Kumari Kanda OP, OP forwarded the FIR to the OC Tamulpur PS, wherein Tamulpur PS case number 258/2018 and the section 30 was registered. Next up. after investigation of the case by the IO and after recording the confessional statement of the appellant on section one before the IO submitted the charge sheet to the charge sheet on finding a prima facie case under section 302 IP against the appellant for murdering the the learned trial court thereafter examined 10 prosecution witnesses and one court witness. The examination of the appellant was done under section 3:1 here. Wherein he denied the evidence that had been adduced against him pertaining the use of a bamboo post from PW4 belonging to PW. Further, where is the refactoring of the perfection?
So page 30.
To question number 11.
Further, the appellant retracted his prospective statement. Now, further, the appellant stated that he had not given any prospective statement when asked by the donor clerk now, when informed by the learned clerk that the court witness dash one, AMFC Bhakta had testified that he had recorded the confessional statement of the appellant. Next slide. This was a very Okay, next, right, yeah, right. The learner trial for thereafter came to a finding that if the finding came to a finding that came to a finding that as the appellant had confessed that he had given came to a finding that that as the appellant had made the confessional statement voluntary under section 164 CRP, without any threat, involvement, pressure or influence of the group. And after giving reflection time, and after being given reflection time. Now, besides the bamboo pole, the bamboo stick used by the appellant having been found near the dead body of the was proved beyond doubt that the deceased had died due to the appellant assault on the deceased with the bamboo. The learner transport also had due to the medical evidence produced by PWA post-mortem report, bracket EXPP.8. It was proved the appellant had intentionally caused the said injury with intention and knowledge that such injuries were sufficient or to cause death of the victim. According to the appellant was convicted of section 30 sentence of infant. The counsel for the learned amicus curiae submit that the only ground for the Senate trial court to convict the appellant. It is on the basis of the 164 statement, their statement given by. Of which he has denied making during his examination and the second one. Further, even if the confessional statement, even if this court is to assume that the confessional statement and the section 164 was made by the appellant. The answer given section number 11 during examination of the appellant at the 61 PCR would amount to retracting the confessional statement made at. Correct. Yes, ma'am. The learned counsel for the appellant for the subject that there were no eyewitness to the crime. And the evidence relied upon by the trial court was only with regard to the confessional statement, the retracted confessional statement of the appellant, and the evidence of PW4 who stated that he had seen the appellant taking away a bamboo post from her compound. And which was lying near the dead body of the deceased. The learned counsel for the learned amicus curiae for the subject that there was no premeditation on the part of was no submitting the alternative that even if it is assumed that the appellant had caused injury on the deceased, it had led to his death. The confessional state, the retracted confessional statement of the appellant go to show that there was no premeditation on the part of the appellant to cause the death of the deceased. In fact, in terms of the retracted confessional statement, the deceased had initially assaulted the appellant on the date that the deceased had. The learned counsel for the appellant for the subject that the retracted confessional statement of the appellant can be used as a basis for convicting an accused, provided right, the judicial officer who had recorded the confession statement has assured the accused of protection from any sort of apprehended torture or pressure from the police. In case he declines to make confession statement. The present case, no such assurance having been given to the appellant by the learned trial. The confessional statement cannot be used as a basis for convicting the appellant. As the provisions of section 164 has to be complied with, not only in form, but also in essence. The, in this regard, is relied upon the judgment of the Supreme Court in the case of Rabindra Kumar Pal alias Dara Singh versus Republic of India, 2011 2S49. Next part. The current counsel for the alert that I could refer the subject that the specification of the bamboo stick used by the appellant while inflicting injury on the deceased shows that it is a stick measuring 5.9 feet in length. This 5.9 feet in length and having a diameter of 2 inches. Okay. Thus, the stick not being a thick stick, comma, the hitting of the deceased by the appellant with the said bamboo stick, comma, even if the same is on a vital part of the body, cannot attract section 302 IP, comma, but the same would fall either in section 304 part 1 or part 2. In the present case, there be no intention on the part of the appellant to assault the deceased, as can be seen from the confessional statement, comma, which shows that there was a chance meeting of the appellant at the scene. The Senate trial court heard in convicting the appellant under section 302. In support of his submission that a small bamboo stick cannot be cannot affect the provisions of section 302. The learned MI has relied upon the judgment of the Supreme Court in Camilo Vaz, Camilo Vaz versus State of Goa, 2009 SPC1. Next. This Paramananda Pegu has been relied by you.
Yes.
To what effect?
So that they are detected something light up. And the corroboration is needed, the
Corroboration is
needed,
needed.
but that corroboration can be other thing than a better of it can actually affect the proof. It's a presumptive.
Next one. The third, I could do this up. That the appellant has been in judicial custody since
2018 itself.
which month? July.
13/7/2018, he was
Since
sent.
13/7/2018. And as the present case does not attract section 302 IP. And as it attracts only section 304 part 1 IP. At best, comma. The case of the petition, the appellant may be convicted under section 304 part 1. Or 2. Which one is more frequent? Who is more frequent? 2 or 1 is more frequent?
One is two, one is life
Huh?
and two is 10 years.
Okay, 1 or yes. Yeah. Say that 2 frequent. Let me say ABC. I forgot out. I haven't done it for so long. 0, 4. Eight. Part 2, we get part. That's all. Anything else? Without? No. Next. Huh? And Mr. R.R. Kaushik to learn an additional PP. On the other hand, submit that the evidence of PW4 and the confessional statement made by the appellant would go to show that the cause of death of the deceased was due to the deadly assault made by the appellant on the vital part of the body of the. We also submit that even though can be assumed that the appellant has retracted his confessional statement made under section 1 was the other. And that corroborate no that comma, a conviction can be made on the basis of the confessional statement. Though the same may need corroboration. However, the corroboration would only have to be general in nature. And the corroboration does not need to be made with respect to all aspects of the case. In particular, correct? In this regard, he has relied upon. He can relied upon the judgment of the Supreme Court in the case of Parmananda Pekuba, state of Assam. 2004, 7 and 6, 7, 7. The learned educated people for the subject that the confessional statement of the appellant having clearly shown that the appellant had admitted to assaulting the deceased with a bamboo stick, and the said bamboo stick having been recovered from near the body of the deceased. Comma. There was no infirmity in the learned falcon convicting the appellant under section 305. As much as a retracted confession can also be the basis for convicting an accused.
And he has defect.
Just submit them. So the appellant had ample time to retract his confession during the trial. Comma. The appellant did not do this, and instead had made uh, had made an alleged retraction of his confessional statement only during his examination of the 316. Submitted. The appellant had only denied making the confessional statement. It had been proved by PW, by CW1, the CW. The judicial magistrate first class were recorded the confession. The trial court and the high court has the right coming to a conclusion that the confession made by the appellant was voluntary, keeping in the above fact. Support of it, in support of the above topic. The appellant has relied upon, not the edited PP has relied upon the judgment of the Supreme Court in the case of Sankaria versus State of Rajasthan, 1978 PS. The learned PP does up that as there is no as the conflicting statement of the certificate is corroborated by the evidence of CW. Shows that the death of the deceased was caused by the call made on the deceased by the appellant. Include judgment the land file should not be different. We have heard the land pass.
The vital part that he has.
Already have mentioned, I think. Okay. Six time. I will repeat it. We have finished the other thoughts. Hearing concluded judgment. The next one. Huh? Hearing concluded judgment. Okay. You go.
May it please your lord. Lordship, I'm appearing as an amicus curiae, lordship. Here, it's conviction under section 6 of POCSO Act. Accused is own father.
Own father.
Yes, lord.
Acha, just a minute. Conviction is based on 6 and 376
No, only 6.
only.
How old is the?
14. 14 years.
According to medical lordship. 12.
According to you, 12.
More than 12? Less than 60.
Anyway, 14, so that 14, so we'll add 14.
164 and her positions are fully corroborated. Remains intact from the beginning.
Yes,
Lordship.
Lordship.
And medical report,
Medical report, Lordship. Medical report, according to the medical report, the last sexual intercourse was about 10 days prior to the examination. That was proof, but one thing that her case is that because of the incident, she was pregnant or she had missed her periods. So, but when the medical authorities wants to examine whether she is pregnant or not, that was not done, but otherwise, Lordship, she was examined. Those examination was not done.
what about high?
Lord, this signing of this bank account, JB account is not working out because of certain issues have cropped up. But in the meanwhile, my lord, what has happened, there has been a developer, the chief electrical engineer of the railway. We are in talks with them that to create two separate accounts so that their money can go into their account and my part of the money can come to mine. So my lord, around 10 days, 2 weeks may be given so that if this works out, then we have no other alternative because we have no other alternative now. So if that works out, then we can proceed with that. That would be
What is the problem?
what has happened, my lord. That is why they are not coming before the court. Time and again, they're not, my clients are also here today. They're not coming before the court because they changed whatever was the agreement. Now they want Altis and themselves to be the account operators, excluding me. So what is the point of going for a JB account? So this kind of mischief is happening behind the scene. So my lord, that is why finding no other alternative, the CE, the civil electrical engineer of railways also suggested, then we can do something that their part of the money, let it go to their account. Your part of the money, let it go to your account. So we are agreeable to that. So my lord may kindly record that and give us 14 days time within which if it works out, we will proceed like that. That is why they are not coming before the court. In spite of several dates, they'll not come. Because if they come here, everything will be clear as water. Things will come out. They want to avoid that. And we have been receiving nasty mails from them also. But I'll not take my court, my lordship to that kind of thing. And last line, that is on 20th July, 1:10 a.m. At night, they are writing. Their person is writing, do not write more. We'll be bound to block your mail with regard. This is the reply.
My lord, I'm on behalf of the applicant Romos. And the last order passed on 19/7/2025. And after the order, the 16/7/2025. And directed the KTC to sign the joint venture form account. And here in the court premises, they signed the 2 pages and thereafter out of this court, they denied to sign. And thereafter I send a mail. So as per the order of the Honorable Court, I sent the mail on 19/7/2025, where the PR portion I mentioned that hence I hereby request you to visit the concerned bank and complete your compliance at the earliest. So I can submit the compliance reports by way of affidavits on the next date, that is 29/7/2025. Already I have signed and the Altis also signed in the joint venture agreements. And the authorized secretary, that is, sir, it is resolved, the meeting, where it is written that resolved further that SBI, it is hereby informed and authorized to honor all checks, bills, bill of exchange, promissory notes, hundis, and any other instruments drawn, accepted, made, and signed on behalf of the company
by the following authorized signatories up to the limits prescribed below. There it is mentioned the Parthasarathi Datta on behalf of the Dromos. There it is mentioned the Langpok Pakpam Chitra Kumar Mitei on behalf of the KTC and Provin Panrajo Chaudhuri on behalf of the Altics. So this is the status, Your Honor. And at present, I have already submitted a document in the bank. This is a kindly.
These allegations and counter allegations will fly until and unless
So already I have
whole-
declared the declaration.
the whole issue is not resolved. Now, they do not come to the court in spite of several dates being given by this honorable court. It's very precious time has been wasted by us before the court, my lord. I'm sorry that we have to be compelled to do that. My lord, that is why, my lord, let the CE and all the parties sit down. And my lord, if they can deposit or transfer that percentage of amount that accused to both the parties, let it be so, my lord. The 14 days may be allowed, my lord.
Sir, I am sharing you one thing, sir, that the incident of 19/5/2025, the CCTV footage has preserved in the railway headquarters where the incident was held that our client, Parthasarathi Datta, was threatening and kidnapping from railway headquarters. And the CCTV footage is preserved there. And this occasion, my client is not at present able to come into the court.
First of all, my lord, the flight could not land. Now he is
No.
threatened, so he could not.
This is,
My lord, he can very well go and file an FIR. That is a different matter. But my lord, if the matter is amicably settled like that, if the chief electrical engineer has, we are speaking with them, that the portion of the amount you take, 1% will be deposited in the other JP account. So my lord, we may be allowed to proceed on that, my lord. That may be taken.
No, sir, kindly watch this document.
You want
Sir,
AP account to you.
Yes, sir, but kindly watch, sir, this is the tender document, sir. Kindly mention the tender document. In page number 151. If the contractor has formed a joint venture of 2 or more persons for implementing the project, these persons shall, without prejudice to the provisions of this agreement, be deemed to be jointly and severally liable to authority for the performance of this agreement. And 2, the contractor shall ensure that no change in the composition of the joint venture is effected without the prior consent of the authority. And it is also mentioned in 152. Kindly watch after 4 lines. The contractor shall ensure that each member of the joint venture shall be bound by any decision, communication, notice, action, or inaction of the lead member on any matter related to this agreement, and the authority shall be entitled to rely upon any such action, decision, or communication of the lead member. The authority shall have the right, that means the railway authority. The authority shall have the right to release payments solely to the lead member and shall not in any manner be responsible or liable for the inter se allocation of payments among members of the joint venture. This is clearly mentioned.
Then why did you agree to opening the joint venture account?
My lord, last
So
time.
already I have signed, and that this is a resolution already passed. And here it is mentioned that that mentioned jointly by mode of operation, sir. Jointly by Sri Parthasarathi Datta, lead member, and any one of the authorized signatory.
My lord, was Parthasarathi Datta present in the court last time? No, he had sent somebody else. These things are they are doing outside the court. Mr. Parthasarathi Datta did not come. He's authorized, he's from Roma, he's the authorized signatory. He was
Not, he is a leading member, sir.
He's a lead member.
That means the tender holder, main tender holder.
He's sending people, but he's not coming to sign it. So, my lord.
He is not appear before, this is the cause, sir, just mentioned.
My lord, to make things clearer, my lord. That is why, my lord, the CA may be allowed to proceed with the proposal that each of the amount that which accused to the parties may be sent to the deposit.
Why should I go into your court?
No, my lord.
The issue is whether you should get it, that if you
So all is signed.
Might also let them come, let Mr. Parthasarathy Datta come, because our owner is here.
What's the only issue here? Was with the opting of a joint venture.
Right.
My lord.
And the branch is Calcutta.
Whatever, wherever, branch Calcutta.
Yes. Yes, dear.
Before open account, that's all.
Yes.
We are always, with,
This is our-
with open arms, with open heart, we are always ready, my lord, because we are also suffering. But what they are doing, they're changing, they're, what they're doing, the operating, the main operator, they're saying promos and Altis will be there, KTC will not be there. That is what is the use of opening a KB account? That is a
No,
problem.
there is mentioned,
And this issue was not decided in their agreement. Who is to operate the account?
Yes, the Altis or KTC, it is there in the agreement, my lord.
That it will be operated.
Yes, my lord, that is let,
It will be operated by whom?
with the lead partner and us, the KTC.
no, all three,
All three, but,
All three.
but mostly two people can sign the check. So if we are
other
not.
survivor. Only any, commonly Promos and any two.
And-
Any one between the two.
That is what I'm saying.
Any
Not
one out of the two.
Anyone out. So KTC.
But
You and KTC open it.
already I have,
That may be ordered, my lord.
we have already signed, my lord, we have already signed in the,
No, the 19th was opening of the account.
Operation.
The operate,
Operate.
the persons who can operate.
Persons who can operate.
but, sir, this is the, out
That
of
is-
the norms of these banks.
How can it
This
be?
is,
an
this is
option?
already, it is mentioned in the MOU, and this is not mentioned, kindly share it before this court. It is mentioned in the,
Let us see the agreement that you have made.
this is the, sir, declaration on behalf of us. The bill is raised, from the railway authority, and thereafter I will share.
Let us see the.
My lord, may indeed come.
And sir, kindly was the share portion, our share is 51%, and the share of KTC is 26%, and share of Altis is 23%.
Yeah.
This is the.
It is more than,
Modern Altis. That is what we are on, my lord.
if KTC is more than Altis, why should KTC be one of the signatories to the operation of the account?
We are agreed for operation, but this is the norms of this bank, sir. This is the,
How can a bank say to the customer that no, so and so will be the partner? They cannot say.
no, already, sir, I have a resolution on that day, I have just submitted you, sir. And there it is clearly mentioned that three authorities signatory.
But it's very common knowledge. Can a
Kindly,
bank,
kindly was, sir,
can a bank dictate its clients that the customers that you be the partner, he cannot be a partner?
Have you been given this? But please rely upon. Give me a copy,
yes,
please rely upon the last page.
it is clearly mentioned, sir. Last 152.
But this has nothing to do with the.
No, my lord,
the
this
bank account.
It's irrelevant. This is between.
This has
What?
nothing to do with
No,
the
my-
bank account.
Now, the only condition of the railways.
Council, are you trying to take this vote up the wrong garden
Sir,
path?
sir, already I have submitted the declaration form, sir, just, I have submitted you. And it is mentioned here that thereafter they done the work, and thereafter he submit the bill to the Dromos, and thereafter Dromos clear all the dues of bills.
Council, I'm not, that's not-
Already declarations are already I have given before you.
the council does not do. So don't think that my low voice is a sign of weakness. Please don't think, you'll be very shocked. See, the thing is that who is to operate the account? Opening is one thing. Now, who is to operate the? That is the only thing. Now, who according to you is to operate the account as per the agreement made by you?
But it is not mentioned in the MOU. It is mentioned, not mentioned that clearly that the operated three
Where is it, where
three
is it
companies will operate. This
the-
is not
who is to
mentioned in
operate
any
the
MOU.
account?
And at the time of tender, it is already mentioned that the decision of the Dromos is final, sir.
That is relating to the what?
Where is
My lord.
the
Kindly,
agreement which says that
this is not mentioned in the
who
movie.
will operate the account?
No, not mentioned.
My lord, this is in the writ petition at page 25, if I read it.
Where is the document signed between the three parties that the joint venture will be opened and that it will be operated by the
Operate, the clause is that, the lead member and, either Altis or, either KTC or Altis. Okay? Right. Okay.
who will be the,
As per the first party, 50, ours is the second party, 26%.
if either of the two,
Either of the
if
two.
either of the two does not fit that the person to the higher percentage. The only issue before for was with that to the office of a joint venture, that was the issue.
My lord,
That, so there are everyone is agreed, but
my lord,
what is that there are.
my lord.
Now, there was
Operation.
one part which you are supposed to take it to hospital. That is whether you can operate on. You're right, right, Mr.
My lord,
Your name,
Hiranmay Devna.
age Devnath, then council for this. Then council for promote, CROMOS, engineer. Huh?
Number two, item number.
And Mr. Item number two. And Mr. R. Sharma for the, for. What is it?
Opposite party and repetition.
Opposite, repetition. What falls from the subject made from, made by the council is that an agreement has been entered between the parties with that opening of a joint venture account. But however, the problem lies in the fact that in the agreement made between the parties, there is nothing stated as to who is to operate the joint venture account to be opened in the SBI Kolkata.
Calcutta. Because of
Where is that? That promos and one party will operate, where is that? Where does it state that the bank account will be operated by you and one of the two other partners? Where does it state that? In the MOU or something?
no, not in MOU. It is mentioned in the resolution and it is
Where? You don't have a copy of the petition also? Which resolution?
joint venture form.
You are a council, you don't have any. Yes, where is it mentioned, Mr. Sharma?
My lord, it is to have the form.
What do I say? As to who is to operate the joint venture. It is the submission of Mr. A. Devnath that the joint venture account is to be operated by Promos Engineer along with one of the two remaining joint venture partners. and the same does not mean that the writ petition will be one of the partners who can operate the joint venture. This is matter up to 10 days.
Mal, 10 days, 10 days. Mal, in the meantime, Mal, we may be allowed to proceed with the railways. If they allow, then we can always, things will be resolved, Mal. That is what I.
But
Mal, if what the railway and we have talked about, my lord, railways and.
I don't know, that is your problem. I am
But
only.
Mal, may just make an
No, no,
observation.
no,
so
no,
that-
I'm not going to go. This is not the problem.
I
of
understand,
court.
I understand, Mal. It is
The
not a
problem
problem.
of the court is complicated.
But Mala,
That you
it-
find a separate petition.
But Mala, it will help the resolution of this
You are
matter.
not helping, you all don't know the fact. You are not.
No, Mala, it is there, Mala, but either KTC or all this. That is the second part.
That is what, as the KTC of.
KTC is the second part.
So you tell me who is to decide that? Who is to decide whether it is to be KTC or? What have I said? And to enable the council to make submissions as to whether. As to who is to decide. The name of the second partner. Who is to operate the JVC account with Promo. Okay,
And Altice is not,
no. What I said is
Either.
who is to decide?
yes,
Who is to decide who is going to operate the JV account? Promos is going to operate, but with whom? Who is to decide that issue?
Operator.
So you show me that. Let's put.
All right, item number 1 may be also listed along with this matter.
my lord, I humbly request one thing that the project is held up for a long time. And I paying before your learned court, your honor, kindly release the amount and direct it to the.
You clarify this issue first. We'll list it this week also if you want.
After 10 days.
We'll list it after 3 days also, 2 days also. We'll list it after 2 days also. You clarify. The joint venture account is to be operated. Open, so it has to be open. It's to be operated by Dromos and who? Is it KTC or Altis? And who is to take a decision? You got my,
Yes.
so you want, I can list it on Friday also, when do you want? Or next Monday, when do you want? Oh, I release it from part, what is there? Oh, why should I keep it? There's nothing.
6.
Because my lord has been. is-
Sixth, I'm not here.
Later than that.
I can do it on fifth if you want.
Fifth, man.
Fifth, huh?